ಹಲೋ ಸರ್, ಇದು ವಾಯ್ಸ್ ಮತ್ತೆ ವಿಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆಯಾ? ಹಲೋ
ಸರ್, ಕ್ಲಿಯರ್ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಹಲೋ ಹಲೋ ರೀ ಕೇಳ್ತಾ ಇದೆಯಾ?
ಹೇಳ್ರಿ ಕೇಳ್ತಾ ಇದೆ ಹೇಳ್ರಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಏನ್ ಮಾಡ್ತೀರಿ? ಆರ್ಗ್ಯುಮೆಂಟ್ ರೆಡಿ ಆಗಿ.
ಹಾ
ಸೀರಿಯಲ್ ನಂಬರ್ 5
ಸೀನಿಯರ್ಸ್ ಇದ್ದಾರಪ್ಪ. ಯಾರ ನೀವು ರೆಡಿ ಇದ್ದೀರಿ? ಪೇಪರ್ ಬುಕ್ ಹಾಕಿದ್ರನಾ?
ಕೇಳ್ತಾ ಇಲ್ಲ ನಮ್ಗೆ.
ಪೇಪರ್ ಬುಕ್ ಹಾಕಂತ ಹೇಳಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್.
ನಾನಾ
ಹಾ
ಪೇಪರ್ ಬುಕ್ ಹಾಕಿ ಪೇಪರ್ ಬುಕ್.
ಹಾ ಮತ್ತೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ನೀವು ಪೇಪರ್ ಬುಕ್. ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಳಗೆ ಏನೋ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇತ್ತಲ್ಲ ಅದು.
ನನಗಂತೂ ಗೊತ್ತಿಲ್ಲ.
ಹಾ
ನೀವ ಹೇಳ್ಬೇಕು.
ಯಾರ್ಯಾರ ಅಪೀಲ್ ಆಗ್ತಾರ?
Serial number 23.
Who is appearing in 23?
23, my lord. I am appearing for respondent number 1. My lord, the council on record, U.S. Yogesh Kumar, has elevated as a judicial member to the income tax appellate tribunal. I used to file fresh wakalat, my lord. I framed for 2 weeks' time.
Your good name, sir?
Jayant Pujari.
Senate Counsel, Mr. Pujari.
Jayant
Jayant
Pujari.
Pujari. 6, 10 to 5.
Fresh
Power
wakalat. For R1.
for R1. Sir, because let it be, is it to be recorded that Mr. Yogesh Kumar has been
Next date, I will file memo, my lord. On that basis, maybe.
What's the matter? The next week of.
Please.
My lord, in serial number 24, my lord, I appear for the respondent number 1. I seek for a short accommodation, my lord. 2 weeks' time may be granted. I'll file the statement of objection.
The request of the Senate Counsel for the respondent. One, kindly inform the petitioner counsel, madam.
Yes, your lordship. I'll do the need.
My lord, serial number
If
28.
your
my lord.
lordship may feel it appropriate, date may be assigned, your lordship.
Week after next, if it is listed, madam.
Okay. Yes, your lordship. Thank you. Obliged.
My lord, serial number 28, my lord. I'm appearing for respondent, my lord. Connected issue is pending before this honorable court, my lord. Hence, it may be listed along with STRP 234 of 2016, my lord.
34 of 2016.
16. Yes, my lord.
15 or 16?
16, my lord.
Kindly clarify, sir. 15 or 16? Your
16.
government advocate is saying it is 1.
My lord, it
Give
is
the correct number, sir.
STRP
This matter along
234 of 2016, my lord.
Along with STRP 234 of 2016. When it has to
Serial
be
number
listed?
30, my lord.
The first, any date is given in that connected matter?
No, my lord. There is no specific date is given in that matter.
Yes, leave it like yes. What is the matter?
Issue pertaining to input tax credit, madam, in VAT.
Not claimed in the monthly.
Is this along with so and so? 30th of March, receipt. Sorry?
My lord. My lord, serial number 30, my lord.
30.
Yes, my lord. It may be posted along same assessees. One more case is posted in last week, my lord. It has been called for after 2 weeks. 10 of 2021, my lord. Maybe posted
Is
with
this matter along with
SCRP.
SCRP number 10 of 2021? Yes. After 2 weeks.
Lordship, item number 29, Lordship. Item number 29, Lordship. I am for the respondent.
Yes.
There is a batch in WA 1431 pertaining to 10-3, Lordship, availment of input tax credit for the subsequent period.
1431.
1431. Yes, my Lordship.
Of which year, sir?
2018, Lordship, 2018.
Writ appeal 1431.
45 matters are pending in this batch of 10-3 batch. ATC 1, last week of March or first week of April.
We list it on the 30th of March. List this matter along with writ appeal 1431 of 2018 on 30th of March.
Obliged, Lordship.
We can dispose of these matters. Yes.
Obliged.
Areas relied upon the decision of the Congress. Dishonorable central investment has not
Yes.
Allowed serial number 15. Both the appeal guidelines really have the matter up to 1 week.
Sir, N.R. Bhaskar is not there. Mr. Amit Deshpande is appeared. Say to delete the name of the learned counsel N.R. Bhaskar and continue to show the name of learned counsel Amit Deshpande for in both of matters. Mr. Matter by next week as played. Next week as played. Yes.
Yes. Three weeks time granted to do the needful. 3 weeks, huh? Yes, 3 weeks. What is this acceptance of service report, government advocate? How many entry tax matters are there? No, it runs to yes, 3-4 pages. Huh? Yes, what are these entry tax matters?
This is what provision of the Constitution, section 301, Article 301, where certain restrictions are imposed by way of imposing a tax on the the silk, which is
All that is covered, Allah.
which is imported from another state. Now they say that the locally manufactured is and tax difference.
Discrimination. It's all covered, sir.
Unreasonable risk.
So we can close this matter. So why it should be listed with all these 4 pages in the cost in the list cost list?
With your lord's permission, my lord.
Yes, Mr. Nalu.
What happened, my lord? Last occasion, my lord, the BP Gandhi and D Venkatesh, most of the cases are represented by D Venkatesh. So then we made a submission in view of death of D Venkatesh and BP Gandhi. The notice has to be served to all the respondents, my lord, because most of the 50% cases are represented by D Venkatesh. So the notice is, that is the reason, my lord, the last occasion the court directed to serve the notice to the respondent. Wherever, in some cases we filed a vakalat, my lord, in some cases it has not been filed. That is the reason.
SPS Chauhan's name is also shown.
His name there. My name is also there. In some cases, some of the clients I represented, I filed a vakalat in 2 cases, my lord. In some of the cases, the notice has to go, my lord. I don't know how many notices have been sent because nearly about 100 dealers are there, my lord.
We consider it if it, most of the cases we think other learned councils are appearing.
Yes, my
Why
lord.
we should agenda matter if it is the same issue is involved, it applies to them also.
My lord, what happened, my lord, in the Jindal stainless steel, my lord, the last pair of the Supreme Court says that each state law has to be looked into, then it has to be decided. That what the larger bench of the Supreme Court has taken a view. Subsequent to that, matters have not been decided pursuant of the Karnataka Entry Tax Act.
Yes,
That is the
we will
reason.
decide the matter.
Your lordship may post any date you are after a week or 2 weeks, my lord. We will argue the matter, my lord. Batch of cases are there. We will dispose of all these cases.
Definitely, government advocate.
I'll get ready, my lord, sir. My lord, can you fix a date?
No, all these matters are already settled, sir.
My lord, there is a difference between an entry tax and a special entry tax. And the earlier judgment of the Supreme Court is on the entry tax. Special entry tax issue not there before the Supreme Court, my lord.
Now, whether this is regarding the virus is challenged hearing?
Yes, my lord. Virus of the provision itself has been challenged. Yes, my lord.
Court officer, whether the virus has been challenged, then why the government advocate has filed a writ appeal?
It was allowed in favor.
The virus has been upheld by the learned single judge.
No, struck down by the learned single judge, my lord. Huh? It was struck down by the learned single judge.
It's been struck down by the learned single judge.
Yes, my lord.
So all these matters are filed by the government.
Yes, my lord.
Section 3.
Why it has been struck down?
My lord, I will just read the last bar of the judgment, my lord. In the result, these petitions are allowed. The provision in the Act, particularly Section 3 of the Act, are declared to be a contravention of sub-article A and B of Article 304 of the Constitution of India, and therefore violates Article 301 and accordingly declared to be unconstitutional.
Violates the Constitution 304 of the Constitutions and violates the Article 301.
So then it has to go before that.
Verify ಮಾಡಿ ಹಾಕ್ಬೇಕಷ್ಟೇ.
Office to verify. So post the matter to the appropriate bench having roster.
With your lordship permission, my lord, last time the bench directed the other state government to file a paper book also. That is not yet been filed, man.
Let it be listed by next week, then we will consider it.
Much of it.
After next one. List the matter by week after next.
I appear in 6.1. This is to be required to be heard. If my lords may pass over, I am ready.
Pass over. Pass over. Yes, 2 weeks time. 2 weeks time granted to do the needful. 2 weeks time we have granted, sir. Yes, Sanmati. Notice, sir. What is the matter? Notice. Then TP, you take notice in all the matter. Yes, because there is delay on IA1 of 2022 as well as on the main appeal. Yes. Yes, 12.
My lords are taking up serial number 12.
Yes, sir.
My lords, I'm appearing in 12 and 13. These are connected writ appeals. My lords would recall the short issue was the revenue was supposed to get back with instructions. This is a case where there's an imposition of advance tax, but now the final assessment order has already been passed. Earlier, I was.
Millards, the instructions are awaited. Millard, in the meantime, Millard, if they are really Millard proceed against Millard, the recovery of both the demands, Millard, prima facie, it amounts to double taxation. Millards may kindly consider Millard for the time, for limited period, Millard, to extend interim protection, Millard, maybe for 2 or 3 weeks, Millard. In the meantime,
Those are matter. Why should we now consider interim stay and all?
Now, Millards, the issue is.
So you get the instructions. We will have by day after tomorrow. Get the instructions.
Now the assessee Millard is transferred to Delhi. Millard, I'm not able to identify the officer itself. Millard, I have to communicate.
My lords, I have implemented the officer in Delhi also now. My lords had allowed the impleadment application. If my lords would kindly see, the application was allowed on 29th of September 2021.
You last may kindly have it after 2 weeks, Millard. I'll try to Millard.
Not 2 weeks, next week. The matter by next week at the request of the learned council appearing for the revenue instructions.
My lords, make interim orders to continue, my lords.
Interim order granted, earliest chance extended to the next date of hearing.
I'm grateful.
Same.
12 and 13 are same.
$55%. When do you want it, sir? No, if there is no no, what? Urgency, no, it doesn't mean that when there is no interim order, then it has to be adjourned, Senate. We'll give a date, sir. No further adjournment on that day. Yes. What's the matter? On 21st March, at the request of the learned council appearing for the petitioner, it's made clear that no further adjournment will be granted on the next date of hearing. Issue notice. Is this matter along with ITA number 103 of 21?
But in the case of the same assessee, ITA 25 of 2022, Millard, wide
ITA
25 of 22, Millard. On 2nd February 2022, Millard, this honorable court, Millard, has admitted all 7 questions. But I have passed on, Millard, the order sheet in also, Millard.
Current council for the current tax revenue submits that ITA number 25 of 2022. It is arising out of the common order.
Yes, Millard. Same issue.
Arising out of the common order. Present hearing and identical substantial questions of law raised. The appeal has been admitted by this court on 2/2/2022. Copy of the said order dated 2/2/2022 is placed to the court. in regard to the aforesaid appeal, the appeal is admitted to consider the following substantial questions of law. 1 to 7. This matter, along with ITN 25 of 2022. Yes, next. No, let you take out notice. They are objecting for submission. This notice.
Lords, in this matter, my lord, the issue, my lord, is relating to, my lords, may kindly recollect, my lord, that the search, my lord, the matter, your lords, is decided on batch of matter. Similar issue, my lord, your lords may kindly consider to issue notice, my lord. Whether, my lord, the concluded assessments, my lord, what is the scope of
153A.
153A, my lord, whether, my lord, it is a case of, my lord, disturbing the concluded assessment on the same issue,
Yes,
or
sir, we have decided this issue already.
please, my lord. My lord, I'm not quarreling on, my lord. This, my lord, we are not disturbing, my lord, the principle of law laid down by lordships, my lord, without there being an incriminating material. The concluded issues cannot be
We should
disturbed.
notice will the other side and
That's
we can
you last
propose
can consider, please, my lord.
yes, notice.
My lord, I appear for the respondent in this matter, my lord. We have against.
For respondent number 4 in this matter, my lord.
Your lordships may kindly have it after 2 weeks. So we have engaged the services of Mr. Rajgopal. He is held up in another matter, serial number 6, my lord, which has been passed over.
Okay,
Kindly.
sorry. Petitioner Yeshu Baba P. Mishra. What is this criminal petition?
My lord, section 14 order is challenged under criminal petition. Section 14 order passed under SURFACE Act is under challenge. All the matters are arising out of one loan account number. Auction sale is under challenge. So all the matters have been connected by earlier order.
Yeshu Baba R. Mishra. He's appearing for the bank.
I appear for the bank. I am for the respondent.
So this petition is filed by whom?
Borrower.
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 Yes, call Yeshu Baba Mishra.
I'm appearing for the petitioner.
Yes, what do you say?
My lord, kindly pass it over, my lord. Senior.
Consider appearing for both the parties 6 times. What's the matter by this week?
Much obliged.
That's great. Yes. Yes. Yes.
Defense had filed appeal. In the meanwhile, relying on the award made in our favor, fixing 2,48,000 per acre, and a 28-year period, 1894 Act, additional price market price was fixed for those who had not preferred the appeal. For all of them, respondent paid the amount at the rate of 2,48,000. Refer to local adult. The local adult ultimately, on the grounds that they will get immediate payment, also to agree to bring down from 248 to 222. Even after that, they are not paying the amount. It is that which has forced us to file a petition saying, now that they are not abided by the conditions in the local adult, please revise the appeal and pay us at 248. Vice memo of calculation, everything was filed. I don't know.
one. And thereafter, they have again execution code. Again, before the execution code, the execution code accepted and acting verification and demanded. Thereafter, they also have appointment of that. And around we have challenged before this on the control.
What simple case in this petition, first, other things. What simple case is 248,000 as determined on the earlier occasion has been paid by the respondents to all the other claimants. Drafting the same memo of calculation. If they want to deny that, then other things would arise.
But you have agreed for 2,22,000.
We have agreed for 2,22,000. Even that they are not paying. That is what we are not pointing out. That is what we are pointing out. If they pay on a particular memo of calculation given by the land acquisition officer for all others and disputing only in respect of these persons who foolishly agreed for a compromise. If they are to dispute it, it would be like in the same modification, payment will be made on different rupees. We have produced.
It's 22,000.
Please, madam, what has happened is, on a reference, 2 lakh amount was announced, making it 2,48,000 per acre.
Yes.
That was some calculation submitted by the special land acquisition officer. According to them, how it is to be calculated. For our enhancement, it was challenged by them by filing evidence. The persons who had not filed application or challenged the award made by the collector, they made an application under section 28 capital J.
Yes.
The board, that is, even if you have not filed the appeal, if it is under the same notification, it is to be paid.
Yes.
That 28 for them, 48,000 was calculated in a particular manner by the land acquisition officer, submitted to the court. The respondents have made the payment.
Yes.
Accepting that. Not that I am saying I should be given 2,40,000. The calculation as made by the land acquisition officer was accepted. They have made the payment. Have produced. After our reducing it to 22,000, again other persons had filed application. For them also, the calculation as made by the land acquisition officer is accepted by them, and they have made the payment which we have produced by election.
Then why did you agree before the 22,000?
Even now, I don't want to go back on 2,22,000. For others, they paid that 2,22,000 as per the calculation made by the special land acquisition officer.
Yes.
Now they say the calculation made by special land acquisition officer, if they are not agreeable, we want to make a calculation on different.
No, no, it is submitted that they have paid as per the local law.
What they say is, we have a particular method of calculation. According to that, I pay only this much. For others, we have pointed out, they made the calculation and paid the amount. We have produced it annexure C and D. If they want to adopt some other method of calculation, why it should be done?
Sir, in which writ petition you are referring to annexure C and D?
How?
ಯಾವ writ petition ಅಲ್ಲಿ?
This is in 12/488 of 2017. That is in WP 12,488 of 2017. Rejoinder failed ಮಾಡಿ. Statement of rejoinder. Rejoinder ನಲ್ಲಿ page 21 annexure C. Just read it. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕಿನ ಹೋಬಳಿ ಮಹದೇವಪುರ ಮತ್ತು ಕಗ್ಗದಾಸನಪುರ ಗ್ರಾಮದ ಹಲವಾರು ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಹೈ ಟೆಕ್ನಾಲಜಿ ಮಾರ್ಗ ರಕ್ಷಣಾ ಇಲಾಖೆಗೆ ಸ್ವಾಧೀನವಾಗಿದ್ದು ಹಲವು ಭೂಮಾಲೀಕರು ಹೆಚ್ಚಿನ ನ್ಯಾಯಾಲಯವು ಎಕರೆ ಒಂದಕ್ಕೆ 2,22,000 ರೂಪಾಯಿಗಳನ್ನು ಹೆಚ್ಚಿನ ಪರಿಹಾರಕ್ಕೆ ಆದೇಶವಾಗಿರುತ್ತದೆ. ಈ ಪತ್ರ ಲಗತ್ತಿಸಿರುವ ಪಟ್ಟಿಯಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಸ್ವಯಂಸೋ ಮಾಲೀಕರು 18 ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸದೇ ಇದ್ದು ಹೆಚ್ಚಿನ ಪರಿಹಾರದ ಬಗ್ಗೆ ಆದೇಶವಾದ ನಕಲುಗಳನ್ನು ತೆಗೆದು ಆದೇಶವಾದ 90 ದಿನಗಳ ಒಳಗೆ 28A ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಈ 28A ಅರ್ಜಿಯ ಬಗ್ಗೆ ವಿಚಾರಣೆ ಮಾಡಿ ಪೂರಕ ತೀರ್ಪನ್ನು ರಚಿಸಲಾಗಿರುತ್ತದೆ. ಇವಾಗ ತೀರ್ಪಿನ ಬಗ್ಗೆ ಲೆಕ್ಕಾಚಾರ ಪತ್ರಿಕೆಯನ್ನು ತಯಾರಿಸಿ ಪತ್ರಕ್ಕೆ ಲಗತ್ತಿಸಿದೆ. ಲೆಕ್ಕಾಚಾರ ಪತ್ರಿಕೆಯಂತೆ ಹೆಚ್ಚಿನ ಪರಿಹಾರ ಬಡ್ಡಿ ಸೇರಿ ರೂಪಾಯಿಗಳು ನಿಗದಿಯಾಗಿರುತ್ತದೆ. ಈ ಮೊದಲನ್ನು ಅತಿ ಜಲ್ದಿಯಾಗಿ ಠೇವಣಿ ಮಾಡುವುದು, ಠೇವಣಿ ಮಾಡದೆ ಕಾಲವೇಳ ಮಾಡಿದಲ್ಲಿ ಹೆಚ್ಚಿನ ಬಡ್ಡಿ ಬೀಳುತ್ತದೆ. ಆದ ಕಾರಣ ಜರೂರಾಗಿ ಠೇವಣಿ ಮಾಡಲು ಕೋರಲಾಗಿದೆ.
So this is per acre it is 61,9007 na? For how many acres it is calculated at 61,0900?
Calculation in the page 22 ನಲ್ಲಿ it is enclosed. Land acquisition officer brought to them 28A ಅರ್ಜಿ ಇದೆ. ಇದರ ಪ್ರಕಾರ ಈ ರೀತಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಇಷ್ಟು ಅಮೌಂಟ್ ನಲ್ಲಿ ಕೊಡಬೇಕಾಗುತ್ತೆ. Relying on my local allowance. All those who had not filed the appeal got the benefit as per this calculation. ಇದನ್ನ ಪೇಮೆಂಟ್ ಮಾಡಿದ. My friend may say, if this is paid, they have at least a semblance of right to dispute the method of calculation.
Now, what is the calculations in your case? Wow, how much they have paid?
The key calculation in a special land acquisition officer additional amount ಮೇಲೆ ಸೊಲ್ಯೂಷನ್ ಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡಬೇಕು ಅಂತ ಏನು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ no, that will not apply. That is how this is going on for all.
What is not applicable according to them?
Applicable
how? What is not applicable?
The interest on additional amount and the solution amount is not applicable. That is how. And
now the question is regarding the interest. Let us see the Lok Adalat award. Page, madam. This is 2,22,000 per acre. Per acre instead of rupees 2,48,000 with all statutory benefits as awarded by the reference code, the amount should be deposited. Yes, you are liable to pay the interest on the solution.
I am putting it on the next pedestal. If for 20 people they have adopted the method of calculation and have made the payment, can they deny it to us?
Yes, where is your statement of what is your stand?
The execution report. Both have filed the award and judgment passed by the local authorities.
They are not challenging this writ petition. They are sought to the respondent has to pay in terms of the order passed by the Lok Adalat. That the award passed by the Lok Adalat. They are not challenging the award of the Lok Adalat. But let us see the prayer in the writ petition.
Because they have said it should be revived. And we are not particular about that really. If Igulu, my learned friend, will take instruction, if they have not made the payment as per.
Now first let us understand what is their case. Yes. We understood the prayer is to quash this order of the Lok Adalat. Now they are not pressing that prayer. They are seeking the compensation in, but as awarded to the land losers in identical circumstances.
Again, after the Lok Adalat, and Lok Adalat has passed the order direction R2. That is with regard to the method adopted by the defense department from the method adopted by the claimants and the IAS office. The claimants stated that they have adopted the method in the amount. However, as the department is not agreeable to calculate the amount in that manner, this on calculating the amount. As for the department it has not been possible to sort it. These matters are already disposed of by settlement. If claimants are not satisfied with the calculations, it is open to them to levy execution so that executing court can pass appropriate orders. Thereafter, before the execution, again dispute arose, and we approach the dishonorable court, and the petition,
Yes.
Consequently, I have consented that this exercise regarding determination of compensation upon the announcement and actually benefits will have to be the entire matter afresh on the basis of memo of calculation. The ratio of the apex score is the soonest case of the executive court shall keep in mind both the decisions and adjustment of calculation on the basis of the memo of calculation. Consequently, the petitions are lodged. The entire excess shall be executing
Recalculated.
the order of the execution challenge. Interest on the additional amount and also on the solicitation for which the decree holders are not entitled.
Why? Why they are not? No. Where did you read that they are not entitled?
In the petition, we have put this on the
Where it has been held that they are not entitled for interest. Where did you read it?
Yes.
Where it is said?
Page number 29.
But it is not said so in the writ petition.
Next petition, it is clearly had. In
Ah. Where you are reading, madam? 29. Ah, yes, I have heard. Yes. Yes. Decision rendered by a larger bench is concluded. Therefore, there is no substance in the contentions of the learned counsel for the defense department. So far as the creation of compensation amount. Compensation when body is concerned, it has been held by the Honorable Supreme Court. Even on supposed case that means operated towards the compensation cost and balance should be appropriated. Light of these two, I invited the parties their remarks, if any, or wish office to prepare memo of calculation. I direct the office to and prepare fresh memo of calculation in these two cases and also in other execution case pending in the this court and as and when required. Market value order is report may not as per this order, it is not this execution as per this calculation calculated in all other cases. As for that calculation only, we have calculated the amount and filed and in this picture, the is pertaining to the petitioner in this case is set as page number 37. And execution number 96. We have 57,000. We had already deposited. We have stated in this annexure R5 also. And the execution court rejected this calculation and we have put on the report in petition number 10617 of 2013, which is the connection R16. This is in execution number 491. In petitioner's case is 496. This is execution number 491. As well there. 42. Data number 6. The average court has held that the landowners are entitled for interest on possession. However, in 216 case, the average court has referred that interest at 9% of possession is payable, but landowners are not entitled for interest prior to the date of the judgment. 2001. We also clarified that such interest
solatium can be claimed only in pending executions, not before the execution. Recovery rate of the judgment in sooner and not for any prior period. In the instant case, the local level has passed an award determining compensation at 20,000 without statutory benefits. As stated, the appellate court in Chindra's case held that the landowners are also entitled for interest on solation. In Murthy's Singh case, the appellate court has clarified that interest is not payable on solation prior to 99. Therefore, the respondent is not entitled for any interest on solation prior to 1990,001. Repetition is allowed to that extent, and the internal order is modified accordingly. The petitioner is permitted for professional mark calculation on the basis of the decision.
So the question is interest on solatium prior to 1999-2001.
Yes, only not even that. All that I'm saying is, with respect of this very modification, based on the award passed by the Lokalala, for all others who had not filed the appeal, who had not even sought reference, amount has been paid by them as per Annexure C. If for the same modification amount is paid as per Annexure C, then they are not entitled to say we will adopt another method.
Annexure C. Yes.
ಅದರಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದ ರೀತಿಯಲ್ಲೇ ನಮಗೂ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ
No,
ಕೊಡಬೇಕು.
sir, in that annexure, see whether interest is paid on solatium prior to 1999-2001.
Prior ಇದಕ್ಕೂ ಎಲ್ಲರಿಗೂ ಕೊಡಿ. Produce it. If they say that
Now, where do we get that interest? Where do we get the interest paid prior to now?
Can you see page 22?
Yes, sir. Ah.
Clear. In fact, reserve at a time. Because here what is happening, in the first instance itself, that's why I pointed out Annexure C. If persons were not come to court, they got the benefit.
In Annexure C, where do we get?
22,000.
Yes.
Interest at 9%. ಆಮೇಲೆ to 15% interest from 23,391 to 23,6,2003. ಆಮೇಲೆ ಅದಷ್ಟು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
So this is 9% interest from 23,789 to 22,790.
Interest ಒಂದು ಅವರಿಗೆ ಹ್ಯಾಂಗ್ ಕೊಡ್ತಾರೆ? ಅದೇ ರೀತಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ.
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್, ಯು ಹ್ಯಾವ್ ಪೇಡ್ ಇಟ್ ಅಲ್ಲ ಫಾರ್ ದೆಮ್.
Annexure C, the opening payment is ಯಾವ ಕೇಸಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದೆ? Page 21. Page 21 ನಲ್ಲಿ
ಹೌದು.
ಅದರಲ್ಲಿ 2,20,000 ಆಗಿದೆ. ಅದರ ಪ್ರಕಾರ ಕೋರ್ಟಿಗೆ ಬರದೇ ಇದ್ದವರಿಗೆ ಕೊಡಲಿ ಅಂತ ಹೇಳಿ ಲೆಕ್ಕ ಬರ್ತದೆ.
Now it is only the question is only the interest on solatium. And only the solatium or any other issue is also. So the interest prior to 1999-2001. 1999-2001. They have paid it from 2001, not to the earlier period.
2001 calculation. The calculation as enclosed is by the special land acquisition officer as they calculate for all the cases. ಇದನ್ನ ಎಕ್ಸೆಪ್ಟ್ ಮಾಡಿಕೊಂಡು ಪೇಮೆಂಟ್ ಮಾಡಿ. ನಮಗೆ ಈ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡೋದು ಬರೋದಿಲ್ಲ, ಇದು ಬೇರೆ ರೀತಿ ಆಗ್ತದೆ ಅಂತ ಹೇಳಿ
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ನಿಮ್ಗೆ? ಬೇರೆ
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇರೋ ಕೊಟ್ಟಿರ್ತಾರೆ. ಈಗ ಲೋಕ ಅದಾಲತ್ನ 21 ವರ್ಷ.
No sir, where do you get the finally the calculation?
3 times executive court accepted the calculation as made by land acquisition officer. 3 times they approached the high court. Again matter is remanded. It is pending till now. 23 ವರ್ಷ ಆಯ್ತು ಲೋಕ ಅದಾಲತ್ ಅವಾರ್ಡ್ ಆಗಿ.
Where is the calculation? The order of the execution court rejecting the memo of calculations filed by both the parties. Next week, sir. Classical case of land losers. That their compensation for having their lands and settlement before the local adalat with a getting the compensation the earliest but late. The petitioners oblique land fighting the litigation in 1999 by virtue of MFA 540 1999 and other connected matters filed by the respondent dash defense estate office against the land losers challenging the award passed by the special land acquisition officer under the provisions of the Land Acquisition Act. This is the fourth round of litigation before this court. Fourth round of litigation before this court. Determination, position, concern. The award and decree by the parties. In order to put equitus to the litigation, the learned prepare a chart in as much as the compensation memo, the compensation determined by the respondent, more particularly with the interest on solatium with respect to the petitioners and the others who had filed the petition or public application date of the act seeking for compensation on the basis of the award and decree passed in the local Adalat determining the a compensation value of rupees 2,22,000 per acre. Learned senior counsel Shri Sonso land petitioners, land losers, inviting the attendant court annexures the filed petition oblique application under section 28A that have been awarded with interest even prior to 1999-2001, wherein the memo filed before the local regard to the directed to prepare it and the same shall be put after serving the advance copy of on the other side. Matter by 17th 16th March. Respondent number 1. Yes. Appearing for the respondent by the chart. Yes. Sir? Registry from Kumar me CGSC respondent number 1 in cases except Madam Anupama Hegden is appearing in one case except petition number 12488 of 2000 and the name of the learner. Those are where because in some matters only your name is chosen. You say shall the council EDC for R1 2017. 16th March, sir. Yes. Mood matter. No, the other side is objecting for any. Petition is mentioned against the order of the district forum. You have to mention. Then you have to go before the National Commission. How this is meant. Already lost the case before the apex court. Yes. Protraction of the matter. You are protracting the proceedings. Having lost the case on merits of the case, and the on to comply the
Amen.
yes. Order sheet code. Apartment. Which apartment? Mangalore. What are the defects? Whether OC is issued? Seven? 10%. Other side is subjective, madam. You are not even complaint with was granted by this court on yes.
city commissioner has not done anything about it.
Which are the other defects? Interim order is also vacated. Yes. Which page of the statement of objects? Which page of the statement of objects? 40. What is the document? So one is the completion certificate. Defective flooring work, telephone point, latches and locks. Defect of the accumulation of water in the balcony to saturate the flow of water.
But they are commonly this is not to extent of issuance of
So apart from this completion certificate, there are other number of complaints to be done by you. It has not been made, even providing you sufficient opportunity. They are in possession of the property, they are residing there.
Yes, I think that they have not allowed the builders to carry out the corrections there. Apart from has been done, the plastering has been done. That whatever could be carried out, the correction into
Now putting the other is very easy. It is to say so, it's very easy. Madam, when they have approached the consumer forum seeking for the services, deficiency in services rendered by you, and after obtaining an order, when they are filed, the execution petition is filed, and the matter was carried up to the Honorable Apex Court for purchasing a flat, they have to face all these consequences. Why should they not allow you to do the necessary corrections? Very difficult to believe all these stories. Yes. Now, which order you are challenging? Let us come to that part. Annexure A. That is in the execution petition. Yes, on what ground you are challenging this order? This annex, on what ground you are challenging these orders? On what grounds, madam?
because this besides the bar section 27 of the nature of contempt, and for contempt, willful default should be there.
Contempt. Execution is nothing but a contempt. Record and we will give the reasons. According to you, section 20 is initiation of proceedings under section 27 of the Act is exempt. Yes.
Section is a limits to carry out the order sections. These are limits that
So we will read willful default and breach. Yes. So we have to read these words into section according to you. Yes. Willful disobedience. It has to be read into the provision of section 27. If there is willful disobedience, then section 27 has to be invoked. Yes. Yes, madam. Forty-one. No, before reading this, reading. No, just we want to see the impugned orders before reading this. There you have raised this ground before the forum and the state. Yes. Yes. Yes, come to page 23 first. The relevant paragraphs you can read it.
The ownership. It is 12, 20, 21.
13. Para 13.
Indicates, yeah. The plan was already for the one by this one.
And the user stated that we are willing to comply with it. Thereafter, the complaint side asked these persons are complied with the order or not. In order to be the truth, we can't put time, 80 and 86 to defense that they are not the partners of the accused number one from the father was the partner. Hence, taken by the it is a partnership from each all consideration of the evidence and documents on record. You have to consider the claim that the accused
There is this can be invoked when there is referring to page 30. No, how does it tell? It tell what it says what is criminal content, civil content. Natural justice has not been complied with.
No, my section is the exercise of powers under Section 27 of the Consumer Protection Act. The nature of contempt proceeding. Looking into the fact that whether there is actually a willful default or not. Not imposed by the state commission and the district court. This aspect has not been looked into.
On the ground that the both the forums, both the forum and the state commission has not looked into whether there is willful disobedience or not.
Yes.
The default should be willful, then only the execution proceedings under section 27 could be proceeded with, according to you. Yes. How do you say that there is no willful disobedience except that occupancy certificate is concerned? Whether you have complied with the other defects pointed out by the district forum.
There was something which there's no space left in the premises. As per instructions is not in the documents. Apart from that, everything has been complied with. And even the order which was passed, this was only with respect to the completion certificate that it should be produced within 3 months.
The order of the apex court. Special leave petitions are dismissed. Which order? Final judgment and 22/7/2014 is in NATI number 2470. That is passed by the National Consumer Dispute Redressal Commission.
As far as the completion certificate is concerned, I've also filed then I have sought the direction of it.
Now, which is the writ petition pending?
Writ petition 51906.
Regularization of the
What is the prior sought in the writ petition? What is the interim order granted in that petition? No interim order. Then how can you take any aid from the tendency of how it will come to your assistance?
Declaration can be permitted for residential building up to 50% of value.
So we will not go into that aspect. We are that then we will be encroaching upon the jurisdiction of the learned single judge, which has to be considered in the pending writ petition. We will not express any opinion. How much is the deviation? Now it is only the execution part. We are concerned with the execution. You have not it in State Commission, further confirmed by the National, and against which you have approached the Honorable Apex Court, and there also you was lost. Yes. Yes. Like answer. Yes. Yes. 37. Yes, ma'am.
Whether disobedience is willful in a particular case, negligence and carelessness can amount, particularly when the attention of the person is drawn to the court's order and it's necessary for the maintenance.
No person can.
These are have been looked at. District Forum as well as the State Commission has not at all gone into whether these defects or whether the orders has not been complied with. Generally,
Petition filed before the Honorable Apex. The National Commission. What is get passed in, whether it is relating to the original proceeding, not the execution. Huh?
They cannot approach. Order of National Commission.
Dismissed. Which writ petition? They approached the National Commission against the order passed by the State Commission. Where is that order? Page. Page number 34. These are the revision petitions filed against the order of the State Commission passed, the order passed in execution. Obvious. No liberty has been sought. Not the review, revision petitions. It's not the review. No. Yes. 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 Let us see this judgment, AIR 2019, but we have not saw the National Commission. Liberty has been reserved. Yes. AIR 90. Place it on record, ma'am. Karnataka House The submission is that about the forum, that is the state commission has not considered of section 27. Willful interested in punishing you. They want their deficiencies to be cured. Despite this court providing you the opportunity, is there any court, any court defects within such a specific time frame? There. Court commissioners submitted the report. Where is the court? ನಾನು ಸರ್ವೋಚ್ಚ ಒಪ್ಪಿಕೊಂಡ ಪ್ರಕಾರ was undertaken before the honorable apex court. That we have seen the apex court, it is only dismissed. You have undertaken before the apex. Where is that order? Let us see the commissioner report. Not also in the, during the exam. So you are let us see. Impose both. Let us see that the commissioner report during the execution. Forty-five. Is furnitures and all. Seventh December. Kenny has visited the property 21/12/2015 at 3 p.m. Even after 2015, from last 7 years, there is no complaints. 10 years. Water leakage was found at the entrance of the electrical room. Water leak also found behind the roof. When we were inspecting the movement of the lift, it got struck due to Ali's reason of overheat. Therefore, we proceeded to note other points. Security rooms not provided or found in the apartment legacy. Second block. Lift is not in working in legacy 2. Lift is not working in good working condition. Landscape garden, children play park, recreation, health club, visitors lobby. According to opposite parties, due to scarcity of place, opposite facilities are not provided. This recreation facilities also you have not provided. No children's area, play park area, health club. Yes. What about this? What is room and the lift? Lift in condition. Fine.
But in any case, you know, this side should have been done by the district council, even if the district ought to have looked into what defects are of what nature and whether they are deliberate. As far as the land, what the whole word was in this question and saying he was very
Made very clear. The commissioner's report speaks the truth. There, what is not there. The purpose of appointment of the commissioner itself is to discern the truth, because the forum cannot visit there and then gather the information. The appointment of the commissioner is for that purpose only. You are not objected to the commissioner's report. Why should be now? Why should be now? Yes. Yes, it has been done. That is the reason. The whole purpose of appointing the commissioner is no. What I did. Look at your attitude and conduct. has already provided you 2 months time. Even that also you have not availed it. Yes. Yes, forget about the completion certificate. What about the other complaints? You received the huge amounts from the purchasers. The attractive and all that they will provide this and that and everything. Finally, nothing. We dismiss this, madam. Will not provide you any opportunity. We find no grounds. Why should we entertain this writ petition? Yes. So where he has said they are not permitted. Where he has said they are not permitted. Those madam, it cannot. But also it cannot assume that if they are not permitted you to attend it. Not interested in punishing you. They want their flats to be in a good condition. Complaints has been made subsequent to passing of the order and during the pendency of this writ petition proceedings. We'll have this matter by next week. No complaints has been. No, we cannot rely upon your affidavit, madam. You will file your affidavit. Who will assert who will whether it the veracity of your affidavit is right or wrong. You say, yes, on oath you will say, you have done, I have completed everything. Yes, yes. No, they should be satisfied. They are not interested in sending you to the jail. Tomorrow, shall we have it day after tomorrow? Or, yes, to find out whether any complaints, further complaints has been made subsequent. Tomorrow or day after tomorrow? Day after tomorrow. Tomorrow. Huh? Yes. No, the execution petitioner, they have to be satisfied. Let us see. Sir, because the execution. You are the owner of only one flat or several owners? For all the flat owners. How many flat owners are here? Seven flat owners. The update the interim order, court, you have not pressed the execution petition. This in this order, stay was vacated by this court. After that, in the execution petition, what happened? Is now this when this order was vacated, interim order was vacated. 23rd November 2021. Before the execution court. Because there is no interim order, you can very well move. Then it becomes this writ petition becomes infectious. If it is executed from November, March, and in the execution petition, you find out all this and place it on record. It is sufficient substantial material. Then we will miss the matter by next week. Yes. Not only the oral instructions with the material, substantial material. Yes. Having considered the arguments advanced by the learned counsel for the respondents, despite the matter on merits has reached finality before the and sufficient opportunity by this court in the present writ petition proceeding order by the state commission in the execution. No defects have been played with. Appropriate to vacation of the interim order by the order dated 23/11/2021 learned counsel for the petitioner submit the completion certificate and the matter before this court in writ petition number 51906 of 2019 and some other defects. Learned counsel fine. The affidavit the petitioners are permitted to file the affidavit. File their affidavit regarding the complaints made pursuant to the order of this court dated 14/9/2021. An advance copy of this correspondence to them public rejoinder if any, public reply if any. Yes, the matter. 17th March, or we'll have it on the earlier date also, some 15th March, 15th or 17th, 15th March, 15th March. It's a minute, I know.
There are 4 appeals before your lordships. Here was for the chancellor. It will be 3839. Permit lots, I may begin with this. Means your lordships may take it will be 3779. And if you are in lordship, it will be 3839. Including towards the chancellor. Page 114. Page 12/6/2018.
Page.
Whereas the tenure of Professor B. Demegoda, Vice Chancellor, Bangalore University, came to an end on 6/2017. Whereas Dr. Jagdish Prakash, Professor, Department of Journalism and Mass Communication, Bangalore University, Bangalore, was appointed to act as Vice Chancellor in Section 16(2) of the Karnataka State Universities Act 2000 until the expiry of its leadership, or until the appointment of a regular Vice Chancellor by notification of even number dated soon. Whereas the deanship of Dr. Jagdish Prakash came to next senior most dean, Dr. M. Munraj, Professor, Department of Commerce, Bangalore University, Bengaluru, was appointed to act as Vice Chancellor in Section 16(2) of the Act until the expiry of his deanship on 29/7/2000. And the appointment of a regular Vice Chancellor by notification of even number dated so and so. Whereas the deanship of Dr. Munraj came to an end on 29/7/2017, and the next senior most dean, Dr. So-and-so, Professor of Civil Engineering, Bangalore University, was appointed to act as VC under Section 16(2) of the Karnataka State Universities Act until the expiry of his deanship on so-and-so. Regular Vice Chancellor by notification of even number dated 28/7/2017. Whereas the deanship of Dr. Ramesh came to an end on so-and-so, and the next senior most dean, Dr. B. Sudesh, Professor and Principal ULC Bangalore, was appointed to act as Vice Chancellor in Section 16(2) of the Karnataka State University Act. Of his deanship on so-and-so, or until the appointment of a regular VC by notification of even number dated so-and-so. As Dr. V. Suresh has resigned from the post of acting Vice Chancellor by letter date so and was as Dr. Shivkumar, Faculty of Science Professor, Department of Mathematics, Bangalore University, was appointed to act as VC under Section 16 Karnataka State University Act until the expiry of his deanship on 6/7/2018 or until the appointment of a regular Vice Chancellor by notification of even number dated 7. Whereas the search committee constituted under Section 14(2) of the Karnataka State University Act expanded to the state government. Whereas the panel of names forwarded by the state government has been examined and considered, now therefore I, Vajubhai Vala, Governor of Karnataka and Chancellor of Bangalore University, in exercise of the powers conferred on me by subsection 4 of Section 14 of the Karnataka State Universities Act 2000, keeping in view merit, equity, and social justice, and keeping in mind the immediate need and interest of the university, hereby appoint Dr. Venugopal K.R., former principal, UBC, Bengaluru, as the Vice Chancellor of Bangalore University, Bengaluru, for a period of 4 years, with effect from the date of assumption of office or till he attains the age of 67 years, whichever is earlier. Now, Lord, this order is dated 12/6/2018, and as per this order, on 12/6/2022 this year, the gentleman, my lords, would cease to hold office as Vice Chancellor. Now, my lord, the thrust of challenge of the first respondent writ petitioner is, my lords, that this appointment was made by the Chancellor without the prior concurrence of the state government, for which reliance is placed, my lords, on Section 14 of the Act. That is the sole ground. May I once take your lordships to Section 14 of the Karnataka State Universities Act before coming back, my lords, to the documents in this case. The Vice Chancellor. The Vice Chancellor shall be a whole-time officer of the university. The state government shall constitute a search committee consisting of 4 persons, of whom 1 shall be nominated by the Chancellor, 1 by the UGC, 1 by the state government, and 1 by the syndicate. The state government shall appoint 1 of the members as the chairman of the committee. The secretary to government in charge of higher education or his nominee, not below the rank of deputy secretary to government, shall be the convener of the search committee. No person concerned with the affairs of the state government, the university, or any college or institution affiliated to the university nominated as the member of the search committee. Now, 4, my lords, is important. Committee shall submit to the state government a panel of 3 persons who are eminent academicians in alphabetical order. The state government shall forward the panel to the Chancellor, who shall, keeping in view merit, equity, and social justice, and with the concurrence of the state government, appoint 1 person from the panel as the Vice Chancellor. So, my lords, when the first,
with the concurrence of the
if there is, my lords, the first search committee, please see the proviso. Provided that the Chancellor may, with the concurrence of the state government, call for a second panel if he considers it necessary, and the search committee shall submit a second panel which shall be final. So, my lords, when it comes to the first search panel, the concurrence of the state, my lords, is mandatory. But if there is, my lords, some deadlock between the state government and the Chancellor's office, then with the concurrence of the state, a second panel can be called for. But once the second panel is called for, the appointment made thereupon, my lords, is final. There is no requirement for 1 more concurrence from the second panel, my lords. That is,
in the first instance, there was already concurrence from the state government.
this is a case where first a committee was appointed. There was some, my lords, disagreement between the state government and the Chancellor's office on who should be appointed. Therefore, my lords, the Chancellor issued an order for a second search committee to be appointed, which had the concurrence of the state government. That search committee, my lords, recommended 3 names, from which this gentleman, my lords, the Mr. Venugopal, was appointed, my lords. And at that stage, the question of concurrence, my lords, does not arise. May I just show your lordships, my lords, the 2 search committee orders. Please come to. It is 11/5/2017. Please, this is not to the principal secretary. The search committee constituted under section 14(2) of the Karnataka State Universities Act 2000, under the chairmanship of Dr. S.R. Niranjan, Vice Chancellor, Gulbarga University, Kalburgi, to prepare a panel of 3 names for selection to the post of Vice Chancellor, Bangalore University, Bengaluru, recommends the following 3 names in alphabetical order. Bhushan, Dr. Sangamesh Patil, who is the writ petitioner, and Dr. Venugopal, who has been appointed. Lord, the Chancellor at that stage was inclined to appoint Dr. Venugopal as the Vice Chancellor. The state government did not provide its concurrence, and there was not some disagreement between the two authorities as to his appointment. Therefore, my lords, in exercise of the power under 14(2) read with 14(4), a second search committee was constituted, and your lordships get that at page 108. Page 108. This is dated 3/3/2018. The search committee constituted under section 14(2) of the Karnataka State Universities Act 2000, under the chairmanship of Dr. S.R. Niranjan, Vice Chancellor, University of Kalburgi, and the S. Indumati, Professor G.C. Saxena, and Dr. S. Ramanan Shetty, to prepare a second panel. Dr. Smith, please mark this. Prepare a second panel of 3 names as provided in the non-obstante clause of section 14(4) of the Karnataka State Universities Act 2000 for the selection of Vice Chancellor, Bangalore University. Bangalore recommends the following 3 names in alphabetical order. Professor N. Ninjay, then Professor Patil, who is the petitioner.
Professor Venugopal remains the same.
He remains.
Yes, he remains.
He remains. And the second panel, my lords, recommended his name along with 2 others. This second panel, my lords, admittedly had the concurrence of the state government as required under 14(4). There is no dispute regarding that, my lords. And accordingly, in exercise of the powers under section 14(4) proviso, the Chancellor proceeded, my lords, to pass the impugned order dated 12/6/2018,
yes,
by which, my lords, he was appointed. Lords, my very respectful submission is that when the second search panel has been constituted with the concurrence of the state government, and the proviso provides that the same shall be final, then there is no question of once again the Chancellor going, my lords, to the state government to seek its concurrence on the second panel as well before making the appointment. That stage, my lords, is already crossed.
Now, according to you, sir, after second panel has suggested the names, concurrence was sought for.
No, we did not need to seek the concurrence.
Then when the concurrence was
Concurrence was sought under 14(4) on the first search panel.
on the first search.
First search. Lord, it so happens on the facts of this case that the state government anyway has ratified the appointment. In fact, Lord, according to us, that gives a quietus to the matter. State government is also in appeal before your lordships. This is not a case where the state government is opposed to the appointment of this Dr. Venugopal. In fact, there is, Lords, the minutes of the proceedings whereby the Honorable Chief Minister has also, Lords, granted his consent. So, in fact, that question in a sense becomes academic. Lordships, kindly come to page 117.
Now, what is the list, the dispute?
Dispute is this Dr. Patil was in the list, comes before the Honorable Court contending that even at the second search committee stage, the concurrence of the state government should have been sought. And as it has not been sought, the appointment of Dr. Venugopal should be quashed. And the learned single judge has not granted that relief, holding that concurrence is required. With great respect, the learned single judge has not noticed that this is a case of a second search committee. Had there been only one search committee, no doubt under 14.4, Lord's concurrence is mandated. But in cases where that stage is crossed,
Now, whether there was any interim order of stay,
report Lord, there was no stay.
then Mr. Venugopal.
He's continuing because the order of the learned single judge has been stayed by your lordships.
June.
May I take your lordships to the order of the learned single judge?
Yes.
That's the only way.
Yes. Yes, sir.
Kindly come to Lord's page 23, para 7. I have considered the submissions made by the learned counsel to the parties. It is well settled in law that when the statute specifies the conditions in which the power is to be exercised, fulfillment of such conditions alone, the power conferred becomes annexed with the duty to exercise the power in that manner. It is equally well settled legal proposition that when the statute prescribes a power to do a certain thing in a certain way, that thing has to be done in that way or not at all. In this connection, reference may be made to the decision of the Supreme Court and so and so. Before proceeding further, it is apposite to take note of section 14.4 of the Act, which reads as under. Note 14.4 is extracted. In para 7 of the statement of objections filed on behalf of the Chancellor, respondent 1, it has been stated as under. It is submitted that out of the above 3 persons, the name of Professor Ninjagowda has already been included in the panel PC of 3, and the concerned file has been submitted for approval. Even though the state government has made some allegations against the selection of third respondent, there was no material document made available on the file in this regard. Further, the second time constituted search committee, after verifying all documents and available materials, once again selected the third respondent as one of the eminent academicians and suitable candidates for the post of Vice Chancellor of Bangalore University. So after considering all these aspects and merit, equity, and social justice, found that the third respondent was meritorious and suitable candidate out of the panel of persons submitted by the search committee for the post of VC. And on 12/6/2018, the Honorable Chancellor has appointed him as Vice Chancellor of the Bangalore University under section 14.4 of the Act for the period of 4 years or till he attains the age of 67 years, whichever is earlier. Thus,
Now, what is his age? Anyway, he is not attained 67 years.
no, I believe he is not. He is represented before your council. We'll just tell you.
Yes.
In 2019, notes he was 63 years old. So he will be 66 now. And therefore, the 4-year period will come to an end on
11/6/2020.
After extracting our statement of objections at para 9, 14.4 of the Act, and the stand taken by the Chancellor in para, evident that the requirement of appointment is not taking place. It is evident that a panel of 3 names was sent, and a panel of 3 names Chancellor has appointed the Vice Chancellor of Bangalore University. The aforesaid appointment is clearly in contravention of section 14.4 of the Act, inasmuch as there has been no concurrence by the state government. Besides that, the issue involved in the instant petition is squarely covered by a decision of the division bench of this court in so and so, which I will just cite and show how has no application. This court is conscious of the fact that this writ petition has been heard without the objections of respondents 3 and 4. However, it is pertinent to mention that the issue involved in the petition has been decided on the basis of the objections which have been filed by respondents 1 and 2 with regard to non-compliance of section 14(4) of the Act. In view of the preceding analysis, the interim notification dated 12/6/2018, by which the respondent number 3 is appointed as DC of Bangalore University, is quashed. And this clerk's order came to be stayed by this honorable court, and he has continued in office. The first statement of concede, my lords, that concurrence was required. We pleaded the facts to show that there were 2 search committees, and after the second search committee, the appointment was validly made under the 14. Second aspect is the reliance on this judgment in state of Karnataka versus Dr. J. The case, for your lordship's consideration. But this is a case where the state government itself filed an appeal.
Here also state government has filed an appeal.
Here the state has filed the appeal against the quashing of the order. In that case, it was a converse case. State's grievance was that their concurrence had not been taken in the first instance. I'm so grateful for that question. It's a directly converse case which arose in this case. But your lordships get the factual matrix at para 2. Mr. VC of Karnataka University retired on the forenoon of so and so. When the file be filled up in accordance with section 14 of the University Act. In exercise of jurisdiction under subsection 2 of section 14 of the Act, the government of Karnataka, for short GOK, constituted a search of 4 members being nominees, 1 the UGC, government, and the syndicate of the university, while the government of Karnataka's nominee was appointed as chairman. The search committee met on so and so, and after due deliberation by the report dated so and so, recommended to the government of Karnataka a panel of the following 3 names in alphabetical order. The government of Karnataka, represented by its principal secretary, in its submission note while enclosing the report of the search committee in a sealed cover, nevertheless indicated the 3 names from which recommended the name. The Chancellor, having regard to section 14(4) of the Act, is said to have perused the proposal of the GOK and applying the principle of merit, equity, and social justice, with the concurrence of the state government, appointed Professor Walikar as the Vice Chancellor by note annexure D, followed by notification dated so and so. The Minister for Higher Education and Statistics, by letter dated so and so, addressed to the Secretary of the Governor, while extracting section 14(4) of the Act, stated, kindly mark this note, that the government of Karnataka does not concur with the appointment. This was a case where the Chancellor, while appointing, in fact said that concurrence was taken, but the state government had addressed a letter saying, no, we do not concur with the appointment. Agreed lots by that appointment. The first respondent, Professor Hinchagiri, instituted the writ petition, advancing several contentions, including that of there being no concurrence of the state government in the choice of the third respondent. Appellant government of Karnataka was arraigned as second respondent. In its statement of objection, supported the writ petition. Kindly mark this. Supported the writ petition. Inter alia, admitting the fact that the appointment of the third respondent was not with the concurrence of the state government, though it did recommend the name of the writ petitioner, the learned single judge, by the order reviewed, dismissed the writ petition. And it is against that dismissal that the state government lords fight the appeal. And the state at para 6, learned for the appellant, who submits that the findings recorded by the learned single judge that concurrence is consultation and the Chancellor had the primacy over the appointment of the VC were contrary to established principles of law. According to the learned counsel, though the notification states that the appointment is with the concurrence of the state government, nevertheless, there was neither concurrence nor consent. And not accepting that statement and position of this state government, the division bench belongs. Extracted at para 13 section of the Act. Then found Lords at para 14. Thus, at the threshold, it must be pointed out that the GOK's recommendation of the name of the writ petitioner from out of the list of 3 names forwarded by the search committee was not in compliance with the statute and hence not requiring the chancellor to take note of the same in the process of selecting one person from out of the panel of persons. Only after the chancellor makes a selection of a person, it is required to be put across to the state government for its concurrence. In other words, agreement or to act in conjunction so as to contribute the same and make it contemporaneous. But concurrence from the legislature. Please come over to para 18. Regard being had to the use of the word concurrence, the parties are required to make their points of view known to each other and discuss and examine the relative merits of their views, making it incumbent upon the chancellor to have made his proposal to the state government, who may or may not have had a counter proposal since that stage had yet to set in. The appointment of third respondent by the chancellor without communication to the state government cannot but be said to be without concurrence of the state government. In other words, in the absence of a proposal being made by the chancellor over the choice of third respondent, the notification annexure E, specifically recording that the appointment is made with the concurrence of the state government, is incorrect and unsustainable. Learned additionally, the circumstances is justified submitting so. The fact situation framing the question of binding nature of the recommendation of the state government and to interpret the meaning of the expression with the concurrence of state government occurring in section 14.4 and the proviso to the KSU Act unnecessary. The third respondent having held office for 4 years from so and so, the term having expired, the post must have fallen vacant as on date. In our considered opinion, though the learned single judge recorded findings over the primacy of the chancellor in a matter of appointment of the VC under the KSU Act, in the facts and circumstances noticed, we think it inappropriate and unnecessary. All questions raised by the learned single judge in the order impugned over the jurisdiction of the chancellor and the interpretation of section 14.4 of the Act are kept open for consideration in an appropriate case. Writ appeal is accordingly allowed, order is set aside, and Lords, though the notification called in question is invalid, nevertheless, there is no necessity to quash the said notification in view of the fact that the term of office of 4 years of the third respondent has expired as on date. So, in fact, there, the term
it had already become infectious. It has become academic in nature.
It's a purely academic issue. The court could have, in fact, closed it as infructuous, but chose to find that there was an error on the part of the chancellor's office by recording concurrence when there was none. Now, this is not a case, Professor Hichigiri's case, which the learned single judge relies on, is not a case of a second panel. Admittedly, in this case, when the Honorable Chancellor sought the concurrence of the state government and the Chancellor could not agree. And therefore, my lords, they relied upon the second search committee. And only then did that, my lords, committee, after looking into all aspects, recommend 3 names to the Chancellor and the appointment.
If there was no agreement, Chancellor proposed the name. If the state government has not agreed, then what is the inference that could be drawn? There was no concurrence.
Which is where Lords 14.4 breaks that deadlock by providing for a second search committee. Because like in a case like this, if the government and the chancellor are not in agreement, the post cannot remain vacant. So a second committee has to be constituted. And that is exactly what was done. If your lordship just see 14.
Yes, we have seen it. According to if agreement between the state government and the chancellor at the first instance, then the second committee, the panel of second committee has under section 14.4 There is no necessity for the concurrence. For the second time.
Because, Lords, that committee also is constituted with the concurrence of the state. Supposing the state government does not concur, if your Lordships see the proviso, even there the state government has a say. And if they don't agree,
For the constitution of the committee.
yes. Just see the language, Lords, of the proviso. Provided that the Chancellor may, with the concurrence of the state government, call for a second panel if he considers it necessary, and the search committee shall serve, which shall be final. So, Lords, the concurrence of the state is sought.
So proviso makes a difference with.
They are two completely different situations. 14.4 is
Only for the first committee. First committee. The proviso is for the second committee.
And even at that stage, Lord's concurrence is required. So it's not that the state government can be ignored. And only after that concurrence does the second search committee come to be constituted. And the report or the panel which is submitted by them, the words.
So that concurrence was there. Huh? That concurrence was there.
Definitely. The second search committee, your Lordship saw, was constituted by the state government. Lordships kindly once see the second search committee. This is not the notification by which it was constituted.
No, that is whether with the approval of the state government, the chancellor with the approval of the state government has constituted the second committee.
The state government has constituted the committee. The chancellor does not constitute it. Lordship just see.
Chancellor
may call for.
May with the concurrence of the state government.
So that panel is in fact constituted by the state government when the chancellor calls for it. And there is no Lord's dispute on that. If your Lordships take the appeal of the state government, the state government, Lords, is clearly of the view that the second search committee was constituted by it, and that it in fact ratified or approved the appointment of this gentleman.
And the search committee chancellor of the state government for a second panel. If necessary. He means it refers to chancellor, not to the state government.
Yes. He considers it necessary.
He considers it necessary.
Right. It's just that not the constitution of the search committee is by the state government. The discretion whether to constitute a second committee is of the chancellor.
Chancellor.
Yes. He then goes to the state for its concurrence to have a second panel. That second search committee, and that committee is constituted by the state. If your Lordships for a moment take the writ appeal of the state government, that becomes clear. Here is writ appeal 3931 of 2019. One, so, sir. Zero. Can you see the facts, para 1?
So what is the stand of the state government? There was no concurrence.
They support the appointee. They say that they have ratified his appointment in any case subsequently. The only person, Lords, aggrieved is this Professor Patil, who was the writ petitioner. The university, the state government, and the chancellor.
They are sailing together.
Yes.
Yes.
The search committee constituted by the state government under provisions of section 14 Act has recommended the name of 3 candidates to R2 herein for the purpose of appointment to the post of VC of Bangalore University. In fact, the search committee constituted by the state on an earlier occasion also had sent 3 names to R2. And as such, a fresh list of 3 names was once again sent to R2. It is stated that in the second list sent to the R2, the name of R1 and R3 were included. Respondent number 2 thereafter issued a notification dated 12/6/2018 appointing R3 as the Vice Chancellor of Bangalore University for a period of 4 years or till he attains the age of 67, whichever is earlier. Notification is enclosed. Thereafter, in the month of December, had challenged the correctness and legality of the said notification. Of which as VC to the university. No imprimatur has been passed in the said petition. As such, R3 till date continues to hold the post of Vice Chancellor. After issuance of notice, the R2 had filed its statement of objections in the said petition. Now, please mark para 4. Without prejudice, it is stated that the state government has concurred to the appointment of Vice Chancellor on 28/12/2018.
Some corrections. Corrections. Yes, sir.
28/6, and that is page 121. 28/6/2018. Further, the appointment of made on the recommendation of the state government as per its search committee does not negate the powers of the chancellor vested under section 14 of the Act. Since, my lords, please mark this, since it is the committee constituted by the state government, the question of the state government once again concurring with the appointment of the Vice Chancellor is a formality, and the same has been complied with in the present case. And it's 28/6/2018, occurrence of the Honorable Chief Minister is forthcoming, lords, at page 'written appeal papers of the university. 3779, which are not fine. This is 12/6, which is the date of appointment. On perusal, governor has approved the name of Dr. Venugopal, former Vice Chancellor Bangalore. Accordingly, the relevant notification is signed and placed in the file. Lordship C, signed by the Principal Secretary to the Chief Minister, and below that, Mukhyamantri, signed by the Chief Minister as well. So, in any case, Section 14 does not, lords, require a prior concurrence. I am making this alternative submission. And even if your lordships hold that after a second search committee also concurrence is required, even then that is not prior concurrence. It could always be, my lords, in the nature of ratification or approval after the appointment is made. And here your lordships find it is made exactly, my lords, 2 weeks. On 12/6, the order is made, and on 28/6, the same.
CH-2.
28/6 is not the minutes, the note sheet.
No, in paragraph 4, that is, it stated that the government has concurred to the appointment of the Vice Chancellor on 28/6.
Lordships get 28/6 at page 123. That is the date on which the Principal Secretary and the Chief Minister have signed. There is a date, lords, at 123, just above Principal Secretary. 28/6/2000. That is the date.
Concurrence was there But it was subsequently.
Grant, even if required, what my basic submission is, at the second search committee stage, no question of concurrence.
Yes.
The section itself says that it shall be final.
Yes.
But as an alternative submission before your lordships, I am submitting that in any case,
It was ratified.
it was ratified. The state government is of the view. The government is not opposed to the appointment.
Yes.
And one section 64 of the same act regarding autonomous colleges.
Yes.
Notwithstanding anything contained in this act or the statutes, ordinances and regulations made thereunder, the university may with the prior concurrence, kindly mark this, with the prior concurrence of the state government, designate for such period as may be specified an affiliated college, etc. Phrase prior concurrence even in 64(3), subject to such periodic review as may be prescribed in the statutes, the university may, with the prior concurrence of the state government, continue the designation. So, lords, when two sections in the same act use concurrence and prior concurrence separately, then, lords, the presumption would be that the legislature intended there to be a difference, and the words prior concurrence do not occur. In 14.4, I rely on one judgment words of the Honorable Supreme Court. Please see para 43. Current development of the Areas Act. Para 43.
Yes.
The High Court, in our opinion, committed a manifest error in holding that despite the fact that the statute uses two different expressions as regards costs to be incurred for construction of schools, hospitals, and community centers, the effect thereof would be the same. In case of the licensee, the words used are at his cost, his own cost, whereas in respect of the others, the words used are at its cost. When different terminologies are used by the legislature, it must be presumed that the same had been done consciously with a view to convey different meanings. Had the intention of the legislature been, as has been held by the High Court, that the cost for such a construction, the fact as to whether it undertakes such construction itself or gets them constructed by its contractors, other terms could not be used by the legislature. The words at his own cost refer to the licensee, whereas in the case of his nominee being either an institution or a person, as the case may be, the words at its cost have been used. The expression at his own cost and at its cost must be held to have separate and distinct meaning. They are not meant to aim a person. Similarly, here, usage of prior concurrence in 64 clearly makes a distinction from section 14 of the Act. And that, my lords, the word concurrence, as in one judgment, this is my last submission, has been held not to mean prior concurrence in the absence of such a prescription. Is the judgment lords in 1988 SCC. Have you come to? We come to page 223, where the clause in question is extracted.
Chancellor, I am appealing for this and other, but 377 and argument. 3839, I am appealing for the Chancellor. 3839 Chancellor.
Page 223, my lords. At the bottom of the page, para 3, or rather part of 18.3, the minority secondary schools accorded recognition. Please, 18.3. The minority secondary school accorded recognition under subsections 1 and 2 shall be managed and controlled under the following provisions. Please come to B, notes. According to the prescribed qualification laid down by the state government for the teachers of the nationalized secondary schools and within the number of sanctioned posts, the managing committee of the minority secondary school shall appoint the teacher with the concurrence, or just may mark this, concurrence of the school service board constituted under section 10 of the act. Now please come to page 227. Of that paragraph, starting with the words under clause B. Under clause, the managing committee is required to make appointment of the concurrence of this board. The expression concurrence means approval. Such approval need not be prior, as the clause does not provide for any prior approval. The purpose underlying clause B appointed in a minority school possess
Not if we
it is left to them, it can even be post facto. My alternative submission before your options. Overall, on a plain reading of the proviso to 14.4, concurrence is not required when the second search committee is constituted and the panel is recommended. And therefore, Lords, the non-single judge is aired in portion. That's my side.
Government is sailing. Yes.
Vice Chancellor. Vice Chancellor should be a post-grade officer. The government shall constitute a such committee. Note, sir, constituting such committee was by state government, consisting of 4 persons, of whom one shall be nominated Vice Chancellor, one by the Tax Commission. The government shall appoint one of the members of as the chairman of the committee. Deputy government. Education or the nominee of the act participated shall be the convener of such committee. No person connected with the affairs of the state government, any college or institution affiliated. Committee shall submit to the state government a panel of 3 persons who are eminent academics. One shall answer. Take equality and social justice. State government appoint one person to the panel as when the chancellor with the concurrence of the state government after the second necessary and the such committee shall submit the second panel. It's clear. Constituency for as not. The prayer concurrence. Again, provided under subsection 4 of section 14. Almost the state agree with regard to
Bangalore University, na? Bangalore City University is different.
Yes, that is subsequently notes. There are
So from it effect from 2001. Yes. That is not applicable to this.
Lords, as the proviso is concerned, that is Lords constitution.
City University and Bangalore North University shall be appointed by the state government subject to terms. Yes, sir.
As Lords, subsection 4 is concerned. As Lords use the expression only with the concurrence. The same Lords, the prior concurrence, Lords, the state law. And kindly see Lords, even subsection also. Vice Chancellor shall subject to the pleasure of the Chancellor and the province of subsection 5 for the office of privacy over Lords, the appointment of and the concurrence Lords of the state government is required. In the present case, Lords, it is not in dispute that 12/6/2000 Lords 18 is the appointment, and on 28/6/2018.
Concurrence was given.
Yes. Now, Lords, the only point that would arise for Lords consideration is that whether the expression with concurrence should be Lords construed that it should be with the prior concurrence of CC. Lords may kindly the first decision Lords has already been resolved. That is 1988 1 CC 206. But I will not be reading that statement. Lords, there is one more decision Lords, that is 2010 TACC 616. University of
Yes.
But it means Lords, 11 to 16 are 11. Lords, page 35. Prior approval of the state government has been held by the board. But when the approval is required, an action is disapproved, it loses its force. He further submitted that the promotion made on the basis of resolution. Therefore, the board and now the state government has put the resolution of the executive council of the topic on 26 by order dated 10/10/2002. The promotions made on the basis of the resolution dated 26.
No, there is the difference between the approval and permission. That was
Lords, it also answers Lords the word concurrence. That is Lords agreement, approval.
that may not be necessary here because
But
approval
ultimately
is
Lords, I am only of the proposition that when the approval was given. So when I said,
Concurrence here.
yes,
Let us use the word what the legislature has.
yes.
Yes.
The next paragraph itself.
Yes.
That's what actually the word approval has been explained. Approval, the act of confirming, ratifying, accepting, sanctioning.
There the difference between the approval and this in if it is approval until case of permission, that is what the yes.
They also consider whether the approval, whether
Permission is prior permission.
prior permission or
Is
prior
yes,
approval.
yes, yeah. Approval means until and unless it is disapproved,
Yes.
it holds good.
Yes.
Yes, it's yes.
In para 13 notes, the same has been considered.
So we'll not go to this
Yes.
approval and permission. Why should to mix up
Yes.
with all this?
Yes.
Let us confine to concurrence.
Next decision. This is application notes. Again, considering notes, the class version case notes, the observations are the same. No matter, even in the case where the notes, this is my alternate notes and submission. Six notes, even approval or notes concurrence of the state government is given in this particular case. If a government notes, according to our submissions, that it is not required. It does not notes that it should be prior concurrence. And accordingly, even assuming for a moment notes that it should have the prior approval or prior concurrence also, then also notes the Honorable Supreme Court notes that ultimately ratified by the competent then it would ratify from the date on which notes that power was passed. It's the prior point. Even in a case where initial action is illegal, the same can be ratified by a body competent date form. This aspect of the matter has not been considered before. Usually, Prasad was he assumed examine the record terminating the service of the offense with the was like resolution by the court of directors parliament. In a regularly in the present case,
Application would always relate back to the date of the act. Right. And so it must be held that terminate. So it relates back to the date of the ratification.
The original order was passed. And from that day onwards, notes it gets validity.
So it relates of the act ratified.
Yes. The observation of the court. Even in a case where the initial action is illegal, it is ratified by a body.
How do you work? If present appointment, has to consider that from the beginning lots of this appointment, there is a concurrence of the state government. Since lots the player concurrence is not lots contemplated.
Gopal has not.
Here also.
3780.
Subsequent to the filing of the appeal, event subsequent.
Yes. Yes, sir.
My lord, one small submission, my lord. In serial number 20, my lord, I had asked for a password.
Check this hour, sir.
Pass over next week. The 20 urgent next week.
Court officer, ಇದು interim order ಇತ್ತು extend ಆಗಿದೆ.
ಅದರಾದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಇದೆಲ್ಲ ಹಿಂಗೆ ಅಲ್ಲ.
ಹಾಗೆ ಇರಲಿ. ಚೂರು ಕೊಡಿವ್ರೆ ಇದನ್ನ ಸ್ವಲ್ಪ ಈ ಕಡೆ ಇಡಿ.
Court officer? Court officer?
ಬರ್ತಾ ಇದ್ದಾರೆ ಸರ್.
ಇದು ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ ಸರ್ 2:30?
ಇದೆ.
ಆಯ್ತು.
ಸರ್ ಹೇಳಿ. ಧಾರವಾಡ ಬೆಂಚ್.
ಎಸ್ ಮೇಡಮ್.
ಸಾಹೇಬ್ರು ಆಡಿಬಲ್ ಇದೆಯಾ ಮೇಡಮ್?
ಇದೆ ಮೇಡಮ್, ಆಡಿಬಲ್ ಇದೆ.
ಓಕೆ, ಸಾಹೇಬ್ರು ಬಂದಿದ ತಕ್ಷಣ ಹೇಳಿ, ಮೇಡಮ್ ಹೇಳ್ತೀವಿ.
ಓಕೆ ಮೇಡಮ್, ಸರಿ ಮೇಡಮ್.
ಸರ್ ಕೋಟಾ ನಂಬರ್ 3 ಇಂದ ಸರ್ ಧಾರವಾಡ ಬೆಂಚ್ ಕನೆಕ್ಟ್ ಆಗಿದ್ದೀರಾ?
ಸರ್
ಧಾರವಾಡ ಬೆಂಚ್ ಅಲ್ಲ?
ಸರ್.
ಹಾ ಅದೇ ಸಾಹೇಬ್ರು ಬಂದ ತಕ್ಷಣ ಹೇಳ್ತೀರಾ, ನಾವು ಅಲ್ಲಿ ಚೇಂಬರ್ಗೆ ಫೋನ್ ಮಾಡ್ತೀವಿ.
ಓಕೆ ಓಕೆ ಸರ್.
ಸಾಹೇಬ್ರಿಗೆ ಬಂದ ತಕ್ಷಣ
ಹಾ ಹಾ ಸರ್ ನಿಮ್ಮ ಮೊಬೈಲಿಗೆ ಫೋನ್ ಮಾಡೋದಾ?
ಹಾ ಮಾಡಿ ಮೇಡಮ್. ಯಶವಂತ್ ಅಂತ.
ಸರ್ ನಂಬರ್ ಹೇಳ್ತೀರಿ?
ಇವರು ನವಾಜ್ ಬಂದಿಲ್ವಾ?
ನವಾಜ್ ಸರ್ ಇನ್ನೂ ಬಂದಿಲ್ಲ ಸರ್. ತಮ್ಮ ಹೆಸರು ಸರ್?
ಯಶವಂತ್ ಮೇಡಮ್, ಯಶವಂತ್ ಅಂತ.
ಶಿವಂತ್ ಸರ್. ಹಾ ಅವ್ರ ಹತ್ರ ಇದೆ ತೊಗೊಳ್ರಿ ಸರ್ ನಂಬರ್.
ಹಾ ಹಾ ಮೇಡಮ್.
ನಿಮ್ದು ಇದೆ ಅಲ್ಲ ಅವ್ರ ಹತ್ರ?
ಹಾ ಇದೆ ಇದೆ.
ಹಾ ಅವ್ರಿಗೆ ನಿಮ್ಗೆ ಹೇಳ್ತೀನಿ ತೊಗೊಳ್ರಿ ಸರ್, ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳ್ತೀನಿ ನಾನು.
ಹಾ ಹಾ ಬಂದ ತಕ್ಷಣ ಹೇಳಿದ್ರೆ ನಾವು ಮೇಡಮ್ನ ಬರಕ್ ಹೇಳ್ತೀವಿ ಕೋರ್ಟಲ್ಲಿ ಹತ್ತಿಗೆ.
ಓಕೆ ಸರಿ ಸರ್. ಬರಿ ಸರ್.
ಸರಿ ಆಗ್ಬಿಡಿ.
Court officer.
ಹೇಳಿ
Madam, serial number 5 ಏನಾಯ್ತು ಲಿಸ್ಟ್ 1 ಅಲ್ಲಿ?
ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಮೇಡಮ್.
ಹಿಯರಿಂಗ್ ಕೇಳಿದ್ರ ಮೇಡಮ್? ಹಿಯರಿಂಗ್ ಆಯ್ತಾ?
ಆಗಿದೆ.
ಓಕೆ. ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಮೇಡಮ್?
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇಲ್ಲ ಮೇಡಮ್, ಅದು ಸ್ವಲ್ಪ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಇದೆ ಅದಕ್ಕೆ.
ಆಯ್ತು. ಓಕೆ ಮೇಡಮ್. ಥ್ಯಾಂಕ್ ಯು.
It appeals stands dismissed. Registry shall disburse the amount in deposit with the account of the appellants to art. Appellants shall furnish the details of bank accounts for complaints. Brother, from Dharwad bench.
Oh, yeah, audio and video is clear,
Yes,
madam.
yes. Copy will be furnished. It will be.
Yes.
Date for signature, sir.
Yes.
Number 2, Gautam Des Yudlal for further arguments.
Parted, sir. Kindly use the honorable judges from Dharwad. Yes.
Whatever the entry model which learns here, people want to with respect to we have not challenged the acquisition at all. Our police, the final judgment copy to that.
No, we are releasing it from parted. You can make a mention before the appropriate bench.
Here, their contention was that we have suppressed the matter of law.
Whatever it is, sir, you can submit your submissions before the appropriate bench. We are releasing it. We are not passing any order. Release from.
We will utilize
20? 20? 26. Next week at the request the learned appearing for R8. Kindly inform the other side. Yes. What is the copies? For the petitioner, because you were not present, the matter has been adjourned to next week. All others were present, respondents. Huh? When? Yeshu Baba Mishra. Here, how you appeared? Sorry? You were not appear. You were not present. You are present through virtual mode. Answer. Sir, London Senior Counsel, Mr. Rajagopal, sir.
My lords. I am ready, my lords.
Sir.
My lords, court's video I think is off, my lords. Yes, my lords. I am in 6.1 appearing for the appointee.
Sir, what was the sir?
I am appearing in writ appeal number 3780 of 2019 for Omkar Kambi. That is writ appeal filed by Mr. Dr. K. Venugopal, whose appointment has been annulled by the learned ethical judge. Now, some facts my learned friend Mr. Sonde has explained that on the first when the search committee was appointed, on the outcome of the first search committee, there was no confluence of opinions between the state government and the chancellor. Therefore, chancellor directed formation of the second search committee. That was done by the state government. And on the basis of the findings of the second search committee, on 12/6/2018, appointment was made. On 28/6/2018, concurrence of the state government is recorded. On dates, I would only say one more thing, Moro. His term is coming to a close on 11th of June 2022. My lord should kindly take page 115 in my writ appeal.
Yes, sir.
115, my lord, is the order of appointment.
Yes, that we have seen, sir. It is for a
Yes,
period
ma'am.
of
Therefore,
4
it is
years.
expiring on 11th of June.
7 years, whichever is earlier. Yes, sir.
No, my lords, it has also been pointed out that section 14(4) does not require prior concurrence. Concurrence can be post the event also. And it has been pointed out the post-event concurrence has been given by the state government on 28th of June. And from 28th of June 2018, there is no illegality or infirmity in the appointment of the present appellant. Now, my lords, I don't have much to say except pointing out that the earlier division bench judgment in State of Karnataka versus Shivayogoppa Hinchigiri, ILR 2015, Karnataka 81. One aspect of the matter which my learned friend did not point out, I would like to bring to my lord's notice. Kindly say, my lords, at the beginning of the first page of the order, date of decision is given at the bottom. Date of decision is 14th November 2014.
Yes.
14th November 2014. Now kindly turn to para 20 of that judgment. The third respondent having held for office for 4 years from 18.
That we have seen and we said it had already become infectious. Now what has been done
Yes,
is
only one aspect I would like to point out.
Yes.
In such circumstances, Constitution bench has said,
yes,
you should not enter into merits of the matter.
Yes.
That judgment I will point out. In the R.S. Nayak versus.
Sir, we are not sitting in judgment over this ILR 2015.
No, I am not saying that. What I am submitting is, it has no precedential value because it decided the thing which we thought not to have decided. Or suppose a person has retired and gone out. There is no assistance from the other side. At that stage, if you decide, it cannot be treated as a precedent is my respectful submission. It is vitiated by issuance of a declaration which the court was not entitled to declare. It is without jurisdiction is my respectful submission. For that, my lords, I am relying on 2 paragraphs in 2 judgments. One is, my lords, judgment number 8 in my compilation, R.S. Nayak versus Abdul Rahman Antule, para 69 at page 140.
Yes. We said he is not appearing.
My lord, I am appearing for the petitioner.
Is Vasant Kumar?
Myself appearing for the petitioner, my lord. Am I audible?
Who is appearing actually?
I am.
In that compilation, if my lords would turn to page 81, judgment number 8 starts. At page 140.
Yes.
In view of the conclusions reached by us, we consider it unnecessary to ascertain which would be the authority competent to sanction prosecution of MLA as envisaged by section 6, though it must be frankly confessed that considerable time was spent in the deliberations in search of competent sanctioning authority. The vital question has become one of academic interest. We propose to adhere to the accumulated wisdom which has ripened into a settled practice of this court not to decide academic questions. The question is left open. Division bench could have done only this much and nothing more. Therefore, it has no precedential value is my submission. To the same effect, my lords, one another paragraph I will read. That is judgment number 7, which starts at page 68. My lords may kindly turn to para 22 at page 79. Last 5 lines of that paragraph only I am reading. The result is that even if we could have given a mere declaration that the price fixation for the season 66-67 in good faith was vitiated by some illegality, such a declaration would have been useless to the appellants. It is well established practice that courts do not issue writs or make declarations which are futile. This I am relying on for 2 propositions. One is for 2 propositions I am relying on this paragraph. One is for the reason that the earlier division bench could not have given a futile declaration. Number 1. Number 2, in the present case, even if my lords were to hold that prayer concurrence and all that, which is not there, no relief can be granted to the petitioner, third respondent, because state has concurred with my appointment. That means his candidature does not have the concurrence of the state government. Therefore, it would be a futile declaration on these 2 issues, my lords. And third point about the futility is, my lords are aware that in a term of 4 years, almost 46 months have expired. Earliest case, my lords are aware, in the excise contract in K.N. Guruswamy versus State of Mysore. This court had taken a view that because it is the excise contract being contractual, it would not lie. Supreme Court reversed it in law, but refused to grant any relief on the ground that almost in 15 days or 20 months or 20 days of 1 year contract is left. Therefore, when hardly any time is left, the interference in writ jurisdiction is impermissible. Then, my lords, my learned friend has already stated that concurrence cannot be read as prayer concurrence. I would only add 2 sentences to that. As pointed out, section 64 speaks of prayer concurrence. Section 14(4) speaks of concurrence. Therefore, there must be a difference between the 2. If this has to be read as prayer concurrence, court would be legislating and not interpreting. High Court job is to interpret the law and not to legislate the law. And another also on this proposition, my lords, about the prayer concurrence and post facto concurrence. 2 judgments I have placed on record. I will not waste my lord's time on that. First is Maharashtra State Mining Corporation. Judgment number 4 at page 54.
Yes.
Paragraphs 5 to 11. There, my lords, in detail, it has been discussed and it is held that ratification relates back. that is at pages 56 and 57 of the compilation. One another judgment, my lord, this even if something is unauthorizedly performed in the first instance, it can be authorized and ratified, and a ratification relates back. That is what is said in paragraphs 5 to 11.
Yes.
Then, my lords, the next judgment at page 59. This is latest on the point. Therefore, my lords, I thought I would venture to cite this from paragraph 6, commencing at page 62. And paragraph 7, conclusion is drawn that approval includes ratification. Then, my lords, even in the worst case scenario, my appointment is valid from 28/6. A question arose, my lord, before the Supreme Court in one case, of course, which may not be directly on the point. An order of dismissal was passed against an employee with retrospective effect. Supreme Court held retrospectivity is bad, but prospectively that order is valid from the date of the order. Even if that analogy is wrong, what would happen is my appointment will be valid from 28th of June 2018 and it will be valid till 27th of June 2022. It is not a case where an incompetent authority has appointed me. No. Competent authority, Chancellor, has appointed me. According to the learned single judge, there is a procedural infringement. Of absence of prior concurrence. He does not even refer to the post facto concurrence because my lord would see the order of the learned single judge. He states that respondent number 1 and respondent number 2 have filed their statement of objections. Respondent number 2 is the state. State had not filed its statement of objections. Therefore, the learned single judge was unaware of the ratification by the state granted on 28th of June. Except the Chancellor, no statement of objection is on record before the learned single judge. Therefore, my lords, my responsibility, that is, my lords, that is the about the splitting the order into the retrospective part and the prospective part and upholding the prospective part is what is done by the Supreme Court in judgment at page 65. That is a judgment rendered by 4 judges, and at paragraph 4, my lords, that it is upheld to the extent of prospectivity. And in the absence of the word prayer, my lords, nothing would turn, whether it came on 12th June or 28th June. And factual difference between the two, Mr. Sondhi has already explained. There was a positive disagreement of the state government in SB Hinchagiri's case. Here there is a positive concurrence and which is put on record, which is also part of the record. Therefore, my lords, this is not a case where the learned single judge ought to have interfered with the appointment. I pray that the appeal be allowed and the third respondent, the appellant appointee, be allowed to complete his term.
Yes, sir. Yes,
Lord, may I make one submission? Lord, in the first writ appeal, my Lord, 3779 of 2019, that has been filed by the Bangalore University against the very same order,
yes,
in which, my Lord, Lord, I adopt the arguments, my Lord, advanced by Senior Counsel Rajagopal, my Lord, P.S. Rajagopal. And, Lord, one submission, my Lord, I would like to make is, Lord, in the impugned order, Lord, a time was sought, my Lord, before the single judge to file objections, both by the state government as well as me, the university. Page number 18, may kindly seen, my Lord. Earlier time was granted 10 days time. Then we sought one more time, my Lord. Time was not granted. My Lord, may bring it to your Lordship notice. Page 18 of the, in my writ appeal, my Lord, 3779 of 2019. The impugned order commences from page 17. Page 18 may kindly be seen, my Lord. The third paragraph, on 12/9/2019, 10 days time was granted to respondents 3 and 4 to file objections by way of last indulgence. However, the objections have not been filed by respondent number 3 and 4. Therefore, the right to file the objections stand closed in terms of the order dated so and so. Having said so, my Lord, the next 4 lines later, the writ petition, my Lord, is admitted for hearing with consent of the learned counsel for the parties, same has been heard finally. Lord, there was no consent at that point of time. In fact, we sought time for want of instructions. Then, my Lord, page 27 may kindly be also be seen, my Lord. In page 27 of the order, same. Para 10, my Lord. Para 10 may kindly be seen. This court is conscious of the fact that this writ petition has been heard without objections from respondent number 3 and 4. However, it is pertinent to mention that the issue involved in this petition has been decided on the basis of the objections which have been filed by respondent 1 and 2 with regard to non-compliance of section 14 and 4. Now, these facts, my Lord, my Lord, clearly establishes that we were not heard before the by the learned single judge, my Lord, while passing the impugned order. Then, my Lord, one more submission. That is, my Lord, and my Lord, the other thing is, my Lord, the respondent number 1, my Lord, who is a writ petitioner before the single judge, had filed a memo on 15/12, my Lord, and produced some certain documents. My Lord, there is a memo filed for additional documents, and my Lord, Xerox copies of some documents have been produced. Lord, in this, my Lord, I have filed a small memo, my Lord. My colleague is there, my Lord. She is giving a reply for that, for this memo, what the respondent number 1 has filed. My Lord, your Lordship may kindly peruse the memo. This has been signed by the counsel, my Lord, who is appearing for the respondent number 1. There is no application. It is not supported by any affidavit. It's only a memo for filing additional documents. Lord, it is not supported. It is not even an IA.
Where is that memo? 15/12 memo.
I don't know, my Lord. 15/12, my Lord. It is there, my Lord.
For 2021 now.
Cause list ತೋರಿಸಿದ್ದಾರೆ non-compliance ಅಂತ ಹೇಳಿ.
In which case?
3779.
3779. First case.
Yes.
Certainly 8 documents have been produced. Xerox copies of 8 documents have been produced, which is not even attested. There is no application has been filed. My lord, this is a writ appeal. It is not even a writ petition before the single judge. My lord, the procedure is an IA need to be filed, and it has to be explained why these documents could not be produced before the learned single judge. And there is a separate provision is there under CPC to file an application. We should leave the seek of the court, my lord, to file additional documents explaining the delay for producing the same. And that apart, that is one thing, my lord, that has not been done. So that apart, your lordship may kindly see all these documents. Document number 1 may kindly be seen. For example, my lord, page number 3 is a document number 1. This is the letter dated 27/11/2008. Lordship may kindly see, note the date of the letter, 27/1/2008. Lord, which is much earlier, about 7 years earlier to the day. And my lord, what is the issue involved here? The issue involved here is the appointment of the Mr. K.R. Venugopal as the Vice Chancellor of the university. And my lord, that has taken place, my lord, subsequently. This is the old document which has nothing to do with this. And all other documents from next document onwards, the lordship may kindly see the dates. 29/1, next page, 29/1/2021. All these documents pertains to the subsequent events which has taken place after Mr. K.R. Venugopal Lord has taken a charge and he has been discharging the duty as a Vice Chancellor. How that is related to with this, the issue involved in this present case? Lord, these things have been produced, Lord, produced just to prejudice the court of mind of this honorable court, which has nothing to do with the, it has absolutely no relevance for this case, the issue involved in this case. And all these documents, they could not have been produced before a single judge also, because these are the documents which has been, my lord, which has the events which has been taken place subsequently after disposal of the writ petition by the single judge. My submission is this memo and additional documents has to be outrightly rejected. All these documents, my lord, I filed a reply also about this. I only stated that, my lord, that first document is pertaining to the previous one, and the other documents are subsequent events which has absolutely no relevance to the issue involved in this appeal. Hence, the memo as well as the documents cannot be looked into by this honorable court. Much less, there is no proper application, there is no affidavit in supporting of that, no reason has been mentioned. And which is, all these documents have nothing to do with the issue involved.
Why Champaklal Chand, Sinhala Shah versus Union of India? AS 64, 1854 has been referred to. No. Yes, sir, that's all.
Yes, my lord. In that view of the matter, my lord, this memo has to be rejected. My lord,
Yes.
the documents, my lord, cannot be considered in this at this stage, my lord, in this appeal. And my lord, the petition, my lord, that apart, my lord, he has got only another, my lord, he would be retiring, my lord. The 4 years term would be completing on 11th of June 2022. My lord, it would be another hardly, my lord, another 2 months will be there, my lord, for his retirement. And at this stage, my lord, this is not the case, my lord, for interference. My lord. That's my submission. That's all, my lord.
What is your submission? Kindly repeat it, sir.
My lord, because my lord, since my lord, he's going to be retired shortly, my lord. His term will be over shortly. My lord, it would be only an academic, my lord, for disposing of the matter on merits. And in fact, my lord, one case, my lord, the senior counsel, my lord, has referred. There is one judgment, my lord, which has been referred, which was disposed of on 3rd of March 2022 by the Supreme Court, my lord, in Gambhir Khan K. Gandhi versus State of Gujarat, which is there, my lord. There, my lord, under identical circumstances in respect of appointment of a VC, my lord, when it went to Supreme Court and there was only 1 month term period was left. So the court has said it would be only academical, it would be decided in appropriate case. It is not a case, my lord, to be decided on merits. That's how, my lord, that in that, my lord, has been decided.
Yes, sir.
That's my submission.
And they use the mic, sir. They may not be. It may not be audible to them.
Yes, my lord.
Sir,
I cannot hear, my lord.
Citations by the different state as well as given today. There are 2 recent Supreme Court judges that are yet to be reported. See online. I have it tomorrow so that I can place all those things and update it in one stretch.
What do you say? Learned counsel for the appellants.
Yes,
Very well,
Tomorrow?
notes, sir.
very well. Right.
Very well, notes. No.
Correct. Senior counsel again for the contesting respondent. In all matters. In all matters.
Oh.
Contesting respondent number 1. Accommodation. To go through the citations referred to by the learned counsel appearing for the appellants and to make his submissions. Release the matter on 8th as prayed. March.
Reference to the Karnataka. That is not the constitutional violation. Has been violated with a lot of Article 301 and 304.
Virus, sir.
Sorry,
You are carrying the virus, sir.
I have challenged the virus.
And all tax matters has to go for the other bench. Because invariably in tax matters, virus of the provision as arranged. Which provision has been challenged?
Right? Amendments were repeated. The Karnataka State Act, the second schedule and fifth schedule, by virtue of which I am an imported silk yarn. So this imported silk yarn was taxed under the second schedule.
Now let us see the prior in the writ petition.
Yes, the second schedule to the Karnataka.
It's covered, Allah. It's covered, Allah. Covered, Allah.
It increased my prayer, petition prayer.
raw silk and silk yarn imported from outside the country. 4% rate of tax is fixed.
Yes, whereas not the same silk yarn, not imported from outside the country, has been exempt under the schedule. So
Imported sugar, there is a judgment, sir. Imported sugar was made liable to tax at some percentage, whereas the sugar manufactured and sold within the country, it was exempted under the 5th schedule. That had come before the court. The court has upheld imported sugar stands on a different footing. It can't be on par with the
locally produced,
locally manufactured so which is sold in the within the state.
Normally, the levy on imported compensate the loss locally. So the courts have held that it is a compensatory in nature and not violative of 304 or 301 of the Constitution. That's according to my understanding. That's what my benefit says.
Yeah, registrar judicial in tax matters matters virus virus you cannot take up any matter.
Invariably in all writ appeals coming up before this writ petitions also one or the other provision is as a challenge.
In all these cases, in all these tax matters, invariably some provisions of law would be challenged. Otherwise, against the show cause notice, it is maintained. Then we will have it for tomorrow or day after tomorrow. We'll see. We get the clarification whether to proceed with or not. Day after tomorrow. Nine.
The respondent.
ಕೊಟ್ಟಿದ್ದಾರೆ ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ಸ್ ಅಭ್ಯರ್ಥಿ ಅರ್ಜುನಂತೆ ಅದಕ್ಕೆ ಇಷ್ಟು ಹೋಗ್ಸಲ್ಲ.
Denial of ITC now that purchase figure was not in existence.
What is the question of law raised?
The respondent is entitled for input tax rate against the purchase affected dealer. So,
how do we say this? Rajguru Impex and Karnataka metal stores are the both yes.
Process में findings of the appellate authority as well as the authority.
Kindly come to the tribunal order, sir.
My lord.
Tribunal order.
I'll directly come to the tribunal order. Section page number 24 starts with so there is no separate heading.
Case of bill trading, that is what the tribunal, that is what the authorities have held. It is a case of bill trading.
It is a case of a bill trading. That the common issues involved in the appeals on hand is with regard to the denial of input tax rate by the authorities below, on the ground that the dealers from whom the appellant has purchased goods have not deposited the tax. The contention of the authorities below in denying the input tax credit is that the dealers so and so whom the appellant has purchased the goods have not paid the tax and are considered as bogus dealers engaged in bill trading. The contention of the appellant is that the appellant has purchased goods from registered dealer, which is evidenced by the e-sugam generated by the authorities during the relevant period. Further, appellant has got a valid invoice and the payments were made through bank and online. The appellant in support of contention has relied on the judgments of the Honorable High Court and this tribunal wide so. We have bestowed our attention to the law laid down in the judgment cited supra, and right from the judgment in Lakshmi Cashew Industries up to Milan Plywood Suppliers, it has been time and again reiterated that the assessee appellant, in order to claim the benefit of input tax, requires to satisfy the authorities that he has transacted with the dealers who are registered at the time of transaction and have issued the invoices to the assessee on payment of input tax. It has been categorically stated that once the assessee appellant has paid input tax to a registered dealer for the transactions affected and in possession of the invoice issued by the selling, he cannot be denied input tax rate for default committed by the seller dealer unless it is proved by the authorities that the dealers were in collusion with each other to defraud the state revenue. In the present case on hand, the appellant has produced the sufficient documents discharging the liability cast on them under Section 71 of the Act. The burden of proof is not static, but goes on shifting. When once the appellant has discharged the initial burden, it is for the authorities to rebut the same by placing evidence regarding the collusion. Mere branding a dealer as a bogus dealer without there being any material to substantiate the batch of writ, the Honorable High Court of Punjab and Haryana so and so has held that no liability can be fastened on the purchasing registered dealer on account of non-payment of a tax by the selling registered dealer unless it is fraudulent, collusion or connivance with the registered selling dealer or its predecessor with the purchasing registered dealer is established. On similar note, their lordships of the Division Bench of High Court of Karnataka in para 9 of the case of Salem States held as under. We do not find that the matter can be stretched to the extent as canvassed. Once the he satisfactorily demonstrates that while purchasing the goods, he has paid the amount of VAT to the selling dealer, the matter should end so far as his entitlement to claim input tax credit. If the selling dealer has not deposited the amount in full or part thereof, it would be for the revenue to proceed against the selling dealer, but thereby the benefit of input tax credit cannot be deprived of to the purchaser dealer. To conclude over and above, all the averments the authorities relied. The appellant emphatically has placed reliance on the ruling recently passed by the lordships of the Apex Court in the case of Arise India and others versus the Commissioner of Tax Delhi so and so. In the said case, in order to discourage the unlawful claim of input tax credit by bogus and non-existing dealers and to curb the Section 9 of Delhi Value Added Tax 2004 by adding new class of dealers to disable them from claim of input tax. The new subclause of DVAT Act after subclause F as under to the dealers or a class of dealers, the tax paid by the purchasing dealer actually been or has been lawfully adjusted to put tax and correctly the respective tax period. As the said amendment mandated the remittance of tax by the suppliers, attempted to penalize the buyer for the last part of the selling dealer, the constitutional validity of the said amendment was challenged in the Arise India Limited. And their lordships of the High Court of Delhi were pleased to strike down this said amendment. While doing so, their lordships gave several findings referring to the decision of the Punjab and Haryana High Court in the case of Gherulal Balchand versus so and so. The Apex Court observed that in legal jurisprudence, the liability can be fastened on a person who either acts fraudulently or has been a party to the connivance with the offender. However, law nowhere envisages imposing any penalty either directly or vicariously where a person is not connected with any such event or an act. Law cannot envisage an almost impossible eventuality if it is held that the person who does not deposit or is required to deposit the tax would be put in an advantageous position, and whereas the person who has paid the tax would be worse, the interpretation would give result to an absurdity. Such a construction has to be avoided. In view of the above discussion, the order passed by the Singh authority upheld by the impugned order of the denying input tax credit to the appellant for the lapse on the part of the selling dealer to deposit the tax collected and tax invoice issued by him cannot be sustainable. Accordingly, the levy of interest and penalty 72. The same is arisen out of addition related to disallowance of input tax credit claimed by the applicant, hence not sustainable in the form. This is the
of tax or any other evidence was available with the department.
My lord, that is the my lord, some intelligence report, my lord, was relied upon by the authorities. My lord, Lordship may kindly turn to my lord in page number 39 for a moment, my lord. My lord, in page number 39, paragraph 5. As per the information extracted from ESOFT, that is department website, it is asserted that the ACCT Enforcement South Zone Bangalore, who has carried out the investigation in the case of the supplying dealer, Mrs. Rajguru Impex, and furnished a report disclosing the sales details for the year 11-12 and 12-13. It is also seen from the report that the above dealer has obtained registration under VAT provision only for the purpose of bill trading activity and attempted to defraud the government revenue. In the case of Karnataka metals sales, the ACCT Bangalore, who has conducted the investigation, has uploaded the investigation report bearing number so and so on ESOFT departmental website, attributing the fact of bill trading activity by the fraudulent dealer and attempted to facilitate the buying dealer to avail the benefit of input claims. As a result of conclusion of investigation authorities, the action of the respondent the input tax credit claims corresponding to fictitious origin are found to be proper and cannot be interpreted. This is the only.
Why you are not deregistered then?
Exactly, my lord. That's exactly our point.
So dealers.
That is exactly our point. Yeah.
Bill trading. Why you are not deregistered them? Why we have allowed them to continue?
When there is an intelligence report, they have not acted, my lord. And Lordship may kindly, my lord, page number 55, my lord. Paragraph 2, my lord, after that column. This office has received intelligence report from so and so Bangalore by report number so was inspected by DCCP South Zone on so and so. Stated that the assessee firm has effected purchases from bogus bill trading dealer M. Rajguru Impex. Availed ITC at 5%. The assessee firm has admitted and discharged the tax liability. Further, it was noticed that the assessee firm had held short of physical.
Where you are reading?
My lord, in page number 55, my lord, authorities. This office has received intelligence report from the office of so and so. It is reported that the assessee firm was inspected by BCCT South Zone and detected that the assessee firm has effected purchases from bogus or bill trading dealer, Mrs. Rajguru Impex, to the tune of 86 lakhs as so and so. During availed ITC at 5%. The assessee firm. Further, it was noticed that the assessee firm had held short of physical stock of goods so and so. On appraisal, the firm has admitted and discharged the tax of rupees 29,988 on such a short stock of goods. It was also observed that the assessee firm has admitted the above omissions and paid penalty of 5,000 towards non-maintaining true and correct books of accounts. In view of the above facts, it is evident that the assessee firm has not maintained true and correct books of accounts as required under VAT Act. thereby committed an offence, resulted in suppression of sales turnover. Therefore, it was proposed to determine the suppressed sales. So, Lord, further on verification of the associate firm affected purchase of goods from the bogus bill trading deregistered dealers, Rajguru Impets and Karnataka Metals.
It's a deregistered.
Deregistered. In view of the above, it is proved beyond doubt the associate firm has produced false purchase tax.
When it was deregistered, when it was deregistered.
Forthcoming. Date of melody registration is not forthcoming. We are also not privy to that. Your reply only. My learned friend could actually regard to the process of deregistration. As per that, come to the date later. Because it is their official website, my lords. So there is a process for deregistering a dealer. It has to be published. That will give a notice. Correct. Let him update the court with regard to. Malad, that has. Malad, the,
No, in those in earlier cases where we have considered in the iron and steel, it was this the address given was some
not existing, sir. Yes.
Or in some cases it was a hair cutting salon.
Yes.
Which was
yes, ma'am. In fictitious, my lord, in fictitious address.
Yes, fictitious address was given.
Yes, madam.
Yes, they were not in existence or fictitious address was given.
Yes, madam.
In such cases, it was held to be bill trading. No such material is available.
And more so, my lord, the e-sugam is generated by the selling dealer on their website, which I have produced along with my invoices. Their website is allowing the selling dealer to generate an e-sugam, my lord. The transaction is complete.
Or it is deregistered. If it is deregistered, yes, then if he gives that number, TIN number, and then he claims input tax credit, certainly is not eligible. And even your intelligence report that does not say so.
Intelligence report it only says that my lord. Trading.
Yes,
that dealer was bill trading.
Bill trading. That's all.
So that's only that. Passing officer that he was deregistered. Basis on which he comes to this conclusion.
That is only Rajguru. What about the other one? There are two firms.
Further, Say further on verification of 56 my lords. Further on verification of books of accounts, it was observed has affected purchase of goods from bogus bill trading, etc. Mrs. Rajguru Index and Karnataka Metal Sales. The details are as below. Both are deregistered dealers, he says. In your above, it is proved beyond doubt that the associate firm has produced false purchase tax invoices and claimed wrong input tax rate and thus proposed to disallow such input tax rate it already claimed and availed in the respective monthly returns from Form 500. See. Paragraph page 59, last paragraph.
It's a reply.
59, my lords. Sorry, 57, my lords. Sorry. 57, my lords. In view of the past, it was proposed to reassess judgment 9 for the tax period 11-12. With the following proposals, it was proposed to restrict the ITC effects.
First limb of the first portion deals with the notice issued. Next, the reply given.
Reply given.
Where is the finding?
My lord, the finding of the assessing officer, my lord. My lord,
page 62.
62, my lord. Paragraph 2 will also strike. Purchase of goods from bogus or bill trading deregistered dealers. The objections filed by the assessee firm regards to proposed ITC reversal disallow in respect of purchases affected from bogus bill trading deregistered dealers was examined. Section 12(4) of the KV text and says the conditions, the provisions to avail ITC, same introduced below for reference. Below he extracts the 10(4). Therefore, burden of proving payment or assessment of tax or to claim ITC is on the assessee firm. Unless the dealer remits the tax collected to the state government, assessing firm is not entitled to avail ITC.
Where is the law to that effect? Unless the tax collected is not remitted by the selling dealer, the purchasing dealer is not entitled to the input tax claim. That is why the Delhi.
Our own High Court also has taken a view that merely because the one dealer has not discharged the tax, I have to pursue him, not to.
Exactly. You have to recover from him.
Exactly. That is our case. Unless the revenue is able to establish fraud, collusion, or bill trading, bogus, deregistered dealer, etc., subject to those conditions. Otherwise, is genuinely purchased. And
what does Packwell says? No, Packwell. There is a reference to this Packwell. Packwell Industries STRP 1 of 2011 so and so. That section 70 duties cast upon the petitioner.
Presumption
that said dealers have remitted the said amount of tax to state government. 70 is
that's
burden of
proof. Burden of proof to be discharged by the assessee. Once that burden of proof is discharged,
the burden of proof does not relate to whether the selling dealer has discharged this liability or not.
Exactly, man. That's all.
In at Dharwad bench, we have rendered one judgment where Mr.
The burden of proof is something else. It says that It is the burden on the dealer to show that he is not liable to tax or any reduction of input tax is credit. That is correct.
Do you have any judgments in your support?
Yes, madam. These are the very same judgments that.
I have, my lord, the material, my lord, this with the, my lord, transactions.
Recently, we have considered all that when we have rendered one judgment, which is that judgment?
Actually, it's been already mentioned in the tribunal's order also, my lord. He said. The Salem Steel, it has been very elaborately dealt with, my lord.
Huh?
The Salem Steel case, it has been very elaborately dealt with this particular subject matter.
No, microqual, it stands on a
That's
it's
for
different.
bonus transaction.
Yes, it was on a different context that it was recorded. The statements were recorded, and in the statements, the statements of this were also recorded. That has been extracted in the internal page 15 also.
Subsequent judgments and all that are relied which are in favor of the enemy. This judgment has been followed in Bagadia.
Bagadia, Bhavani enterprises. All that we have recently considered.
Yes.
Bhavani. They, yeah, yes. Now kindly come to this page, paragraph 11. The purpose, the main reason for us to hold so is because kindly come to, we also find that, come to that portion, para 11. You got it?
Yes. We also find that these two of the dealers of whom input tax credit in the present case for consideration.
They were the parties in microqual. So they were the bogus dealers there. So, this namely SLV and TD and company. Very recently we are considered, headed by this bench means and one judgment we have rendered at Dharwad bench. One judgment, but very recently in Bangalore only we have considered. Good officer. And a cause list. Which are the judgments you are relying upon?
I'm relying upon this this honorable court's equal bench.
Ah.
16 in STRP number 171. I have furnished already. Page number 1. In that, my lords, if I can.
Rajesh Jain.
Yes, my lords. But yet not set us in.
Interim order is there?
No interim order. But my lords, this honorable court has given a finding already, which I am relying upon. At para 9, my lords, at page 7 of that judgment, very clearly held that we do not find that the matter can be stretched to that extent as sought to be canvassed. Similarly, in this case, once the purchaser dealer assessee satisfactorily demonstrates that while purchasing goods, he has paid the amount of VAT to the selling dealer. So, my liability ceases the moment I make a payment to the selling dealer and I have a proof of that payment, which I have furnished, my lord. I have paid through bank selling dealer. And the matter should end so far as the entitlement to claim the input tax credit, it actually rests there. Now, if the selling dealer has not deposited the amount, then it would be for the revenue to proceed against the selling dealer. Why deny me of my rightful input tax credit, my lord? One second. No, let me complete, sir. No, let me complete. I was hearing.
Invoices also.
Invoices and my lord, movement of goods also has to be there. Exactly, my lord. So that is where I am coming from. I filed an objection, a detailed objection. Reminded in the file. Objections in this part. There very clearly I have brought out all the kinds of factors which are to be read along with my cessation of liability. Now, A is the invoice, my lord. And more importantly, it is the generation of e-Sugam generated on the website of the petitioner, my lord. Now, if I want to buy a material from A, B, C, D dealer, what I do is I place an order on him. And what he does is he goes to the website of the petitioner's official website and generates e-Sugam with the invoice, where the invoice details, the transport details, there is a whole list, my lord. I have produced all the requirements under law for the e-Sugam to be generated. I'll read out if you, my lords, permit. And that also in terms of a notification, my lord. Notification itself, the e-Sugam had to be.
Section.
Yeah. Recently, very recently, here we have considered all this, because
one more development. This Rajguru, there was a reassessment on that for the same period. Reassessment on. order saying that this is non-existing. This is in the records, it is order passed. They say that it was closed since long time, and the whereabouts of the dealer was not known. Hence, the notice was served to eviction on the door of the business premises on 15/10/2013, and another was not known. Mr. Raju as home. So, as inspector of the business premises concerned, so reported that said premises was locked. The enforcement officer has stated despite all efforts the case. The selected seal open. Officials on entering the said place of 76 inches.
It's like hair salon. What iron and steel cases, there was a lot of bill trading cases. It was a big scam actually.
Verification of the registration details and other documents like copy of house rent agreement, shop agreement. It was found that ironically both were executed on 5/3/2007, which goes to show that the dealer will
Place it on record.
Perhaps not brought to the notice of the tribunal also, it seems, but the tribunal also has not given any finding on this.
What is the assessment here? There, tax period. Tax period 10, 11, 12. And the other one? Karnataka metal sales.
The investigation report is that
Metal sales. So what is the commodity here? Iron and steel. Aluminium profiles and self-adhesive tapes, etc. What is that iron and steel you are reading there?
dealer was providing tax savings to buying dealers by forming a syndicate to facilitate one stream of food or to regularize unaccounted or undeclared purchases. In this case, it will be saved for further investigation and legal action under section 424/68. Additional Commissioner of legal I was verify whether reassessment of wage or whether reversal of input tax is done. So this is the possibility. Correspondence between the
The matter is entrusted to COD and all. Why you have not deregistered such traders?
registration certificates of both the books are there. Right? The asset officer says that okay. In case I could have deregistered because the investigation not connected to that.
But immediately you would have deregistered them. They were not the existing dealers. Is it for further arguments? Matter was heard for some time. Matter was heard for some time. Learned counsel, learned AGA for the state. 6. Some accommodation. Get further instructions in the matter. Is the matter?
My lord, 21st, my lord.
21st.
Yes, my lord.
21st March. As prayed for further arguments. We have considered all this fact file. Dharwad bench also. Here also in this bench also. That is Dharwad bench Surya Narayan. That is different altogether. That may not be helpful to you. The bench here we have rendered one judgment. Maybe.